Today we will be exploring what the age of Trump is doing, especially when it comes to protecting policy and the legal implications of his second term. We'll begin, first of all, with the first panel that'll explore the judiciary's evolving role in a democratic governance and constitutional boundaries, addressing issues from birthright citizenship to digital speech and regulations. We will then shift on to a second panel where we will explore trade and economic policies, analyzing the move toward neo-mercantilism and the legacy of tariff politics, as well as the future of global commerce. And that'll bring us to our keynote. And for our keynote, we will explore the complex ethical landscape of cryptocurrency, exploring Trump's pro-crypto pivot and the broader societal implications of digital finance. That'll lead us on to our final panel, where we will look at foreign policy and financial regulations, assess how changes to immigration, trade, and diplomacy could reshape both domestic and global dynamics. We look forward to a day filled with critical insights and meaningful discussions. I would like to take a moment to thank our amazing symposium editors, Jenna and Lindsay, for setting all of this up. I would also like to thank our advisor, Professor Reed, who will also be participating in today's symposium, for all of his hard work in guiding us throughout the year. And so with that, we will get started. I would like to introduce Professor Tom Berg, who is the James Obstor Professor of Law and Public Policy here at St. Thomas. He will be giving our opening remark. He teaches and writes about constitutional law, religious liberty, and intellectual property, and his latest book, with some relevance to our current polarized politics, is called Religious Liberty in a Polarized Age. Please welcome Professor Tom Berg.
Oh, thank you, Anissa, and it's my pleasure to welcome the speakers and all of you to this symposium. I'm here on behalf of the Dean. Daniel Kelly is our Dean. Dan had to be out of town today, but he sends his welcome too. So the symposium title, again, not to be repetitive, is The Age of Trump, Projecting Policy and Legal Impacts in a Second Term. And of course, this is a fitting, even compelling moment at which to gather to discuss the new administration's policies. As President Trump himself might say, everybody's talking about it. Nobody's ever seen anything like it, right? So what an intellectual banquet you will enjoy today. The speakers here, those on the screen now and through the rest of the day, will serve up a variety of ideas and arguments that will be rich, savory, and I would guess from time to time spicy. So as Anissa said, the first course of this banquet is the assortment of talks on judicial power, constitutional limits, and global governance at 9 o'clock. Then the next panel, Trade and Tariff Policy, at 10:30 a.m. Now, just to be clear, that is not a panel on tariff policy as it happens to be at 10:30 a.m. It's a panel at 10:30 a.m. on tariff policy. Okay, so then on to the lunchtime speech on cryptocurrency, an under-examined topic, and finally in the afternoon, the panel about the administration's likely impacts on two kinds of security, as I understand it, national security and individual financial and retirement security. So I congratulate Anissa and Jenna and Lindsay and the other editors, all of you, and Professor Chuck Reed, your advisor, for serving up a mixture of legal constitutional analysis on one hand and policy analysis on the other. Next Tuesday, here at the law school, speakers, we will have a lunchtime event addressing only the kind of constitutional legal issues concerning the administration's assertion of executive power. But today's event truly makes good, I think, as I read the speakers, I was struck by how it really makes good on the name of your publication, the Journal of Law and Public Policy. So bringing those two disciplines together allows us to see, for example, how legal institutions and rules and norms shape policy, constrain policy, how policy pressures, on the other hand, sometimes strain or even break legal norms, and no doubt a number of other kinds of relationships between the two that speakers will bring out during the day. So, looking through both of those lenses, law and policy gives a wider and sharper, more vivid view of the many issues and challenges that we face today. So, have a wonderful day. Enjoy the intellectual banquet, as well as the, at least for those of you here, the in real life meal at lunchtime. And have a great day, and thank you for coming together.
Good morning. Our first panel is focused on judicial power, constitutional limits, and global governance. Panel 1 explores the legal and constitutional challenges that could shape a second Trump administration, examining the judiciary's role in democratic governance, executive power, and global policy. Topics include the historical and legal foundations of birthright citizenship, the ideological impact of minoritarian judicial appointments on civil rights, the shift from free trade to aggressive neo-mercantilism, and the constitutional limits of government regulation over digital speech in cases like TikTok. Together, these discussions assess how shifts in law and policy could redefine the balance of power between the executive, judiciary, and broader democratic institutions. Beginning the panel is with Mohammed Khalilzadeh. Mohammed Khalilzadeh is a JSD candidate at the University of Illinois at Urbana-Champaign, where he previously earned his master's degree with high honors. Under the supervisions of Professors Thomas Ullin and Jason Mazzoni, his thesis explores the role of courts in the constitutional backsliding processes. Mohammed is currently working as a research assistant for Professor Jason Mazzoni, focusing on the state courts which have developed history and tradition framework in interpreting unique features of their constitutional history and practice. Mohammed has received Cali Awards in empirical methods in law, international criminal law, and professional responsibility for his exceptional academic performance. Mohammed is also one of the attendees at the 2025 Constitutionalism Summit held at the University of Texas, Austin, where he will present his research and engage with other constitutional scholars. In addition to his academic work, Mohammed has several articles and books published in his home country of Iran. Next, you will hear from Sarah Oakes. Sarah Oakes is an associate professor at Elon University School of Law and teaches legal method and communication and international law courses. Her scholarly expertise lies in the field of international criminal law and transitional justice, with a focus on the prosecution of mass atrocities before international and hybrid courts and the use of transitional justice mechanisms in a post-conflict and settler colonial societies. Professor Oakes has published over a dozen scholarly works which have appeared in publications including the Stanford Journal of International Law, the Michigan Journal of International Law, and Seton Hall Law Review, and has presented on these works throughout the United States and Europe. Prior to joining the Elon Law faculty, Professor Oakes served as a U.S. Fulbright Scholar and a visiting researcher at the University of Gothenburg in Sweden, as well as an assistant professor of law at the University of Louisville, Brandeis School of Law. Before joining academia, she clerked for the Honorable Judge Carl J. Barbier on the United States District Court for the Eastern District of Louisiana, and subsequently practiced tort and insurance defense and maritime law in New Orleans. She proudly earned her Juris Doctor from Loyola University New Orleans College of Law, where she graduated second in her class. Professor Ox is also a novelist. Her debut thriller, The Resort, was published in 2024. It was a Book of the Month Club selection and an Amazon editor's pick and has already been translated into several different languages. Her second book will be released in 2025. Last but not least, Jennifer Safstrom is an assistant clinical professor of law at Vanderbilt Law School and teaches the Stanton Foundation First Amendment Clinic at Vanderbilt Law School. Before joining the faculty at Vanderbilt Law, Professor Safstrom worked as counsel at the Institute for Constitutional Advocacy and Protection and a supervising attorney at the Clinical Teaching Fellow, and has been a clinical teaching fellow with the Civil Rights Clinic at Georgetown Law School. She has also served as the Dunn Legal Fellow at the American Civil Liberties Union of Virginia. Professor Safstrom earned her JD at Georgetown University Law Center and her BA at the University of Miami. Her legal scholarship has been published in multiple law reviews, including Clinical Law Review, Georgetown Law School Law Journal, Yale Journal of Law and Feminism, and Harvard Latinx Law Review, among other journals. She has been quoted in the Washington Post, Above the Law, City Lab, and Breitbart, and in other local and national publications. Please join me in welcoming our first speaker, Mohammed Khalilzadeh, to begin.
So, my topic is about minoritarian judges. Every study has its motivations, and my study has its motivations as well. So, I'm looking for Trump-appointed judges on circuit courts of appeals, and I am in particular looking at their judicial behavior on civil rights cases. The motivations for my study is that there are enough sample of both minoritarian and majoritarian judges appointed by President Trump, and I'm going to explain what those terminologies mean. The second motivation is that there was enough time to assess judicial behavior. So there was approximately between 5-7 years, perhaps, to be able to evaluate, because there was enough cases and these judges already ruled on some of the cases, because there has to be some time to be able to evaluate the judges and their judicial behavior. And obviously President Trump got reelected, so there's this point. And also there is significant influence of on judiciary by President Trump, because as you might have known, President Trump appointed nearly as many as federal appeals court judges as Obama in half of the time. As you can see in this screen, President Donald Trump appointed 54 court of appeals judges compared to Barack Obama, which is 55. Relatively similar, but just Barack Obama had 8 years, Donald Trump had 4 years. My presentation addresses two questions. First question is, who are minoritarian judges? And the second question is, are minoritarian judges more ideologically extremist on civil rights cases than their majoritarian counterparts? So in order to address who are minoritarian judges, I'm actually relying on the definition by Gruel and Zofer article in 2008, published in California Law Review. Says judges appointed when their confirming senators receive the minority of the votes of population. And my standard would be IPV, or implied popular vote. And implied popular vote particularly looks at the last election of senators. Basically means that I am calculating all of the senators who voted in favor of a particular judge and all of the senators who voted against that particular nominee. And I am looking at the last election of those senators. And if the first number, the people who voted in favor by their last election, by in popular vote, supersedes the second number, the judge is majoritarian. Otherwise, the judge would be minoritarian. For example, we could look at Judge Amol Sapar of Kentucky to be United States Circuit Court judge for the Sixth Circuit. And he was appointed by President Trump, and he got 52 votes in favor and 44 votes against. But on the other hand, that 44 represented the states with more popular vote. The senators in that 44 had more popular vote compared to that 52. And that means that Amol Sapar is a minoritarian judge. Obviously, there's a lot to calculate there, but I'm just showing you the brief picture because I have to look at each senator and how he or she got elected. And I'm doing this for every obviously how many senators, how each senator's got his or her vote, but also for each judges, as you can see, most of the Democrats voted nay, and most of the Republicans voted yay for nomination of Judge Amol Sapar. The hypothesis, once again, is minoritarian judges tend to be ideologically extremist than majoritarian judges, and it derives from structural checks and balances. And my study in particular looks at the Senate confirmation hearings compared to the previous studies, which only looked at the president. They assigned the party of the president for the ideological behavior of judge. If Democrat appointed the judge, they said it's a liberal judge. If Republican appointed judge, they said it's a conservative judge. But my study is a more nuanced because it looks at the confirmation hearings to assign the particular ideology of a judge. The hypothesis would be, as I described, and this hypothesis obviously comes from the framers. The idea of Federalist Number 51 that the structure of government must furnish the proper checks and balances between different departments, and argues that James Madison in Federalist Number 51 in particular argues that the branches were meant to have checks and balances, were meant to be separate, and therefore to have checks and balances. And my hypothesis came from obviously minoritarian judges got less of implied popular vote compared to majoritarian counterparts. They had less robust checks and balances, and that led to them being more ideologically extreme. And obviously, the constitutional structure impacts judicial behavior. That was my hypothesis to analyze here, focusing on Article 2, Section 2, Clause 2, which says the president shall have the power by and with the advice and consent of the Senate appoint ambassadors, other public ministers, and consuls, judges of the Supreme Court. So advice and I'm looking at the advice and consent of the Senate in particular, and the confirmation hearing of the Senate. Once again, also there were surprisingly there were Trump appointees who got many supports from their Democratic colleagues. And so I was able to distinguish between minoritarian judges appointed by President Trump and majoritarian judges appointed by President Trump. For example, Judge Ralph Erickson got confirmed by 95 versus 1 vote against. Judge Amy Eve voted by 91. All of the senators who were present, unanimous support. And obviously, these are only minority of judges. Majority of Trump-appointed judges got less of Democratic support, and they were far more controversial. The first question after my calculation, I'm presenting the answers, is answered in this way. There were two-thirds of Trump-appointed judges who were minoritarian, represented by 36-1, and one-third Trump-appointed judges who were majoritarian, had majority popular vote support, represented by only 18. And that in itself says a lot, because compared to previous administrations, President Obama, President Bush, and all, this is the first time that we have majority of judges lacking implied popular support. Basically, majority of judges, as you see, two-thirds of judges being minoritarian. And this raises constitutional crisis for itself. And I'm looking also. I said my study had two questions. The first question was for minoritarian judges. The second question is minoritarian judges and their political ideology, and in particular looks at whether minoritarians tend to be more conservative. I sampled and coded 540 judicial opinions, and based upon that, mean ideological score for minoritarian judges happened to be 8.92 for minoritarian judges, compared to 7.28 for majoritarian judges. Each, obviously, there's a scale between 0 to 10, 10 more, the most conservative, 0, the most liberal. These are the opinions I have quoted, and as you can see, minoritarian judges had more conservative judicial ideology, 8.92 compared to 7.28 of majoritarian judges. And as you can see, obviously, the p-value is statistically significant. Therefore, null hypothesis is rejected. And also I had a histogram. It shows that generally ideological score of judges appointed by Donald Trump is heavily toward the right. You can see approximately 15 judges had 10 out of 10 conservative opinions. But as you can see, there are also some judges who had their ideological opinion score is 6, 5, and 4. So also one of the interesting facts was that when I looked at ABA rated non-qualified judges, all of them happened to be from the minoritarian sample. And Judge Stephen Grass, who was confirmed on 8th Circuit by 50 to 48. Judge Jonathan Copes, who was confirmed on 8th Circuit by 51-50. Basically, the vice president broke the tie. And Judge Joseph Walker, who was affirmed on DC Circuit by 51 to 42. And Judge Lawrence Van Dyke on 9th Circuit by 51 to 44. All of these judges happen to be minoritarian. I had my regression analysis. As you can see, majoritarianism is statistically significant, but also I looked at some confounding factors to maybe able to help understand the study. Some alternative explanations, and that independent variables included race, gender, coded circuit, and the Congress. Coded circuit is like whether the judge was influenced by liberal circuit or a conservative circuit. Was, for example, fourth quarter would be a more liberal one than the seventh. The Congress that appointed these judges, and as you can see, none of those reached statistically significant, therefore even giving more value to minoritarian independent variable, which basically is a significant factor in the outcome. And every study has its potential limitations. And I would like to. So my study's potential limitations were that, first and foremost, I looked at only Trump judges. I looked at circuit courts of appeals judges. I didn't look at district court judges. There might be different dynamics in district court judges. And I only looked at civil rights cases. There are two discussion points lastly that I would like to mention. First is counter-majoritarian issue. As you know, federal judges are appointed, they are not elected. Therefore, Alexander Bickel raised this point that judicial review is illegitimate. Why he said judicial review is illegitimate? Because unelected judges overrule the elected representatives. Whether we agree or not, the response would be we still elect the representatives to ensure accountability of judges to the people. But this form of accountability is shortcut now in particular, because as we have seen, most of Trump-appointed judges happen to be minoritarian and therefore lacked implied popular support. The second point of the discussion was institutional checks and balances and constitutional backsliding processes. And as I noted, the fundamental question would be why minoritarian judges happen to be more polarized, even though they have been appointed by the same president, President Trump. And the answer to that would be they received less institutional check from an independent branch of government, which happens to be here, Congress, and majoritarian judges had more bipartisan support, received an independent check, a more robust check from an independent branch of government, Congress. So that would conclude my presentation, and I'm looking forward for the questions.
At this time, we'll welcome Sarah Oakes.
Okay, well, first of all, thank you so much for having me. A huge thanks to the JLPP and all of the amazing editors who made today possible. I'm so happy to be here. As I was kindly introduced, my name is Sarah Oakes. I'm an associate professor at Elon School of Law in Greensboro, North Carolina. And the question I am trying to answer with my presentation today is whether the International Criminal Court can survive a second Trump presidency. So it's kind of a loaded question. And to start with, because I'm assuming, maybe rightfully, maybe wrongfully, that not too many of us in the audience today are super familiar with the International Criminal Court, I'm going to begin with just a couple minutes talking about what the court is, its background, and really how it functions. So just as it sounds, the International Criminal Court, or the ICC, as it's colloquially referred to, is the world's permanent international criminal court. It was specifically designed, to prosecute the crimes of most significant concern to the international community as a whole. It was created in 2002 by its governing legislation, which is a multilateral treaty known as the Rome Statute. And it's grown, so today it includes 125 states parties or nations that have ratified the Rome Statute. However, probably the most notable about its states parties are the nations that are not states parties to the court, those who have not signed on or ratified the Rome Statute. And those are countries like Russia and China, and most notably for this presentation, the United States. So some of the most geopolitically powerful nations in the world are not members of the ICC. The ICC is a court of last resort. It is not intended to really supplant state sovereignty and states' rights to prosecute their own citizens. It's actually only intended to step in when national courts are either unable or unwilling to prosecute crimes that fall within its jurisdiction. Because of this, the ICC has very limited and kind of very strict jurisdictional limitations. One of these jurisdictional limitations is that the court can only hear cases involving crimes that are either committed by the nationals of a state party or that are committed on the territory of a state party. As of 2025, as of early this year, the court, despite having operated for more than 20 years, has only achieved 6 individual convictions for core crimes. And these are the crimes within the ICC's subject matter jurisdiction, including genocide, crimes against humanity, and war crimes. The court, just by its inherent nature, is something of a quasi-political institution. So while it is very much, a court, it's a judicial institution, the subject matter that it deals with and the way that it's structured and operates really kind of blends issues of law and geopolitics. So the court handles, as I mentioned before, cases that involve crimes that are of the most significance to the international community. This essentially means that the court is regularly hearing cases involving geopolitical conflicts or conflicts that, carry great weight on the geopolitical stage. In addition to this, the court, unlike many other international courts that hear disputes between two nations or multiple nations, the ICC is a bit unique in that it is a criminal court. It hears only charges against individual defendants. And in line with this, it does not recognize things like head of state or sovereign immunity, which means that the court can and has gone after or charged individuals who are either former or sitting heads of states, along with high-ranking governmental and military officials. In addition to this, the court is particularly vulnerable because it lacks anything like a formal enforcement mechanism or a police force that will enforce its rulings. Instead, the ICC is completely reliant on its states' parties to cooperate with it and further its rulings. So for instance, the ICC can issue arrest warrants. However, it cannot execute those arrest warrants. It relies on its states' parties to arrest the individuals subject to these warrants should those individuals enter the states' parties' territory. So moving on to the United States and the ICC. As you may have guessed by the title of this presentation, the court has had a very tenuous relationship with the US since the court was created. Initially, the US was a strong proponent of the court. It was one of the primary countries advocating for an international criminal court. However, at the Rome Conference, the conference that created the Rome Statute, the US ultimately developed significant reservations to the court, and specifically regarding concerns about the court's jurisdictional reach. And even more specifically, the fact that under the Rome Statute, the court in specific circumstances can exercise jurisdiction over individuals of non-states parties. So because of this, the US ultimately ended up voting against the Rome Statute at the Rome Conference. Nevertheless, in his last day in office, President Bill Clinton ended up signing the Rome Statute. However, in his signing statement, he mentioned that he believed the Rome Statute had significant flaws, and he recommended that his successor, President George W. Bush, not move forward with ratification. Bush made good on this advice. He did not send the Rome Statute to the Senate for ratification. And in fact, even went a step further. His US ambassador to the UN at the time, John Bolton, who later became the National Security Advisor under President Trump during his first term, ultimately wrote to the UN and said, we as the US are formally unsigning the Rome Statute. So because of that, and today the US is neither a signatory nor a state party to the Rome Statute. And despite that kind of weird, controversial start to the Bush administration, things were pretty placid, pretty smooth under both the Bush and Obama administrations. Obama even occasionally supported the ICC. However, this entire relationship dynamic really changed under Trump's first term. So a little bit of context about what was happening in the ICC at the time that Trump was serving his first term. In 2017, the court was embroiled in this backlash regarding what's called their Africa problem, which are allegations that the court has heavily and exclusively focused on prosecuting crimes committed by African nationals. In fact, all of those 6 convictions I mentioned before that the court has achieved are of nationals of African nations. So in an effort to kind of respond to this backlash, the prosecutor at the time, who's pictured on the right here, her name was Prosecutor Fatou Bensouda, she began considering ways that the ICC could expand its investigations beyond just Africa. And in furtherance of this, she sought to open an investigation for crimes committed in Afghanistan since 2003. The scope of this investigation included crimes committed by 3 groups: the Taliban and related terrorist groups, the Afghan National Security Forces, and critically and most controversially, the United States, and specifically by CIA officials pertaining to the unlawful detention and treatment of detainees held in secret detention facilities or black sites operated by the CIA throughout Afghanistan. So even though the US is not a state party to the court, because the alleged crimes were committed on Afghanistan and the territory of Afghanistan, which is a state party, the court ultimately concluded that it had jurisdiction. And Prosecutor Bensouda obtained approval from the ICC to open her investigation, and this authorization was ultimately issued in March 2020. Ever since the prosecutor began her investigation or began requesting authorization, the US responded very intensely, I could say. And specifically, the response was primarily by these 3 individuals on my slide: President Trump, Secretary of State Mike Pompeo, and at the time, National Security Advisor John Bolton. They began numerous verbal attacks against the court, referring to it as a kangaroo court, challenging its legitimacy, authority, and jurisdiction. But when the ICC authorized the investigation into Afghanistan in 2020, things really kicked up a notch. Trump issued an executive order declaring a national emergency caused by the ICC and authorizing sanctions against ICC personnel, including issuing sanctions against Prosecutor Bensouda herself and another high-ranking individual in the ICC. This included freezing any assets that they had in America or that passed through America, revoking visas, and blocking their entry into the country. This was a huge blow to the ICC, and it was really the first time that anything like this had been done. It was an abundantly clear message not to mess with the United States. And to some extent, the ICC seems to have taken this to heart since that executive order was issued and sanctions were imposed. There has been very little discussion from the court about any movement with regard to the investigation into American crimes in Afghanistan. It does not seem like there has been much progress made on that. And with the transition from the Trump to the Biden administration, things generally thawed between the US and the ICC. Biden revoked the sanctions against the ICC and even supported the ICC's investigation into Russian crimes committed in Ukraine. However, things really began to sour between the ICC and the US shortly before Trump took office for a second time. So In November 2024, the ICC formally issued arrest warrants for Israel's Prime Minister Benjamin Netanyahu and his former Defense Minister Yoav Gallant for alleged crimes against humanity and war crimes committed during the ongoing war between Hamas and Israel. This was understandably controversial since Netanyahu is first a sitting head of state who is officially being declared a war criminal, and second, because Israel is such a close ally of the United States. And unsurprisingly, Trump, who is such a staunch proponent of Israel and its position in the war with Hamas, was outraged by the court's decision. So on February 6th, just weeks into, taking office for the second time, Trump issued yet another executive order, once again declaring a national emergency posed by the ICC and authorizing sanctions against the new prosecutor, Karim Khan, and any former foreign person who has materially assisted the ICC in, quote, investigating, arresting, or detaining a person without the consent of that person's country of nationality. And it's still pretty early days. The effects and consequences of this executive order we're still kind of waiting to see what those will be. But the intention behind these executive orders is very clear: to pressure the court into dropping the investigations into alleged crimes committed by the US and its allies. And unsurprisingly, it has picked up traction. It's gained traction. Several European countries have already vowed not to arrest Netanyahu, and it's unclear how much this is related to, Trump's pressuring. But they've agreed not to arrest Netanyahu, even those states parties who have an obligation to do so should he venture into their territory. And this has gone so far as even very recently, the country of Hungary has withdrawn from the court over the ICC's arrest warrant for Netanyahu. So all this really begs the question that I've been considering, which is, can the ICC really survive a second Trump presidency with all of its political vulnerabilities and the crises that it's been enduring? Will this mark the end of the ICC? And so my answer to this specific question, whether it can survive, is yes. I do believe that the International Criminal Court can survive a second Trump presidency and its controversies. But I say that with a big caveat. And this is only by embracing a narrative of institutional resilience. And so what I mean by this is that up until this point, the court really has just found itself in this recurring cycle of enduring and recovering from crises. First, it was the Africa problem. Then it was Trump round one. Then it's pushback from superpowers and Trump round two. And amidst this, there have been a lot of high-profile kind of PR crises that the court has been dealing with regarding strikes and salaries and, disputes between judges on the court. And so the paper that I'm currently writing is really looking at how the court needs to change, not from the inside out as to how it approaches cases and things like that, but more from the outside in. So how it presents itself to non-states parties like the United States and to states parties who are, supposed to be loyal to the court and upon whom the court relies on to cooperate with its rulings. And so a lot of this, I'm jumping ahead, a lot of this really stems from a lot of the kind of steps that I suggest to embrace a narrative of institutional resilience and present the court as one that is as a formidable judicial institution, include things like improving public relations and crisis management, promoting greater advocacy and education regarding the court, and creating a clear prosecutorial strategy to enhance conviction rates so that the court is seen more as kind of a strong, far-reaching international court. So I'm still in the process of kind of working out what exactly this will look like, but I hope that this presentation sparks some discussion, and I look forward to all of your questions. Thank you again.
At this time, it's my pleasure to introduce our own Professor Charles Reed. He is a professor at law at the University of St. Thomas Law. Professor Reed is a distinguished scholar whose work bridges legal history, jurisprudence, canon law, and whose research has shaped our understanding of the historical rights, the influence of Roman and medieval law and modern legal systems, and the evolving role of canon law in contemporary society. Professor Reed holds a JD and a license in canon law from the Catholic University of America, where he has also organized a symposium on nuclear arms policy. He later earned his PhD from Cornell University, focusing on medieval Christian origins of individual rights. Over the course of his career, he has collaborated with some of the foremost legal historians, including Harold Berman, and has contributed to thought-provoking legal scholarship on topics ranging from inheritance law, judicial precedent, and Alexander Hamilton's constitutional vision. And with that, I will pass it on over to Professor Reed. Thank you.
Well, thank you for that gracious introduction, and I will not be focusing on canon law this morning, but I will be focusing on themes of legal history. And what I'm concerned with in particular is the relationship of conspiracy theory, moral panic, race, and the Chinese Exclusion Act. The Chinese Exclusion Act has gained sudden relevance when we talk about the Trump era, because it is from the Chinese Exclusion Act, litigation surrounding the Chinese Exclusion Act, that the idea of birthright citizenship was developed and adopted in the 1890s. My presentation will focus on first the issue of conspiracy theory, and conspiracy theory and moral panics. They both develop in the soil of public anxiety, and you can see this often in issues like, I'll give an example, the priestly pedophilia crisis. The priestly pedophilia crisis was and has been an enormous crisis for the Catholic Church, causing enormous harm to victims and to the Catholic Church itself. But it also leads to the development of conspiracy theory and moral panic. Because you ask yourself, if a Catholic bishop can conceal the sex crimes of clergy, what else can they do? And this leads naturally to an atmosphere of public anxiety and suspicion, and an understandable suspicion, understandable fear of what else has been done. Conspiracy theories also arise when we see the inexplicable happen. Take the assassination of John F. Kennedy. The assassination of President Kennedy was a sudden shock. And young, vigorous, forceful personality gunned down inexplicably in the streets of Dallas. And then you have Lee Harvey Oswald, the assassin. And Oswald seems like such an inconsequential figure next to this world-defining, world-changing act. The inquiring minds, if you will, want to know, well, what really happened here? And of course, that's only enhanced when we see the Jack Ruby, the mobbed-up Jack Ruby, in turn murdering Lee Harvey Oswald. So conspiracy theory is the product of public anxieties. We also have moral panic. Moral panic is closely related to the idea of conspiracy theories, but still somewhat different. Moral panic involves the sudden emergence of fear that usually on the part of the establishment, that some sort of threat has emerged. The idea of moral panic was created really by the work of Stanley Cohen, who took as a case study the mods and the rockers, two groups in 1960s England who staged a series of loud weekend parties that led to some drunkenness and arrests. And suddenly this leads to the emergence of a panic on the part of the British establishment about the youthful hooliganism. And so you have tremendous fear that the young have been turned into these mobs of hooligans, and so we have this tremendous disproportionate response, leading to the adoption of laws that are panic-driven, so that is that's the idea of moral panic. Stanley Cohen insists that the idea of panic should be literally and seriously taken. It's not a form of speech, not a metaphor, but it is a genuine panic on the part of, very often on the part of elites, to what they perceive as a threat to the established order. We see this. We see the idea of moral panic playing out in the COVID pandemic, playing out, if you will, on both sides, if you will, of a polarized divide. For example, I take in the paper, I explore the idea of ivermectin. Ivermectin was a wonder drug for many purposes, developed in the 1970s and promoted for many purposes. The discoverers of ivermectin eventually won the Nobel Prize. So it's a serious medication that has many useful uses, both for human use and veterinary use and elsewhere. Early on in the COVID crisis, it was tested for its efficacy against the COVID virus. Proved not to be efficacious. But it was taken seriously as a possible cure early on in the crisis. This leads to a tremendous and polarized, fractious atmosphere of the United States. 2020, 2021 leads to a divide between exponents of ivermectin, generally on the political right, and opponents of it, of its use, represented by the establishment, you see a moral panic play out really on both sides. The exponents of ivermectin tended to be fearful, suspicious, mistrustful of vaccines and of more orthodox, more established ways of doing medicine. And at the same time, you had an establishment that freaked out. That's not too strong a word, freaked out. You had, for instance, many right-thinking people promoted something known as the Herman Cain Award for people who may have boasted on Facebook that they used ivermectin or some other alternative form of medicine and subsequently contracted COVID and died. So that certainly is evidence of an extreme moral panic, fitting Stanley Cohen's classic definition of a moral panic, driven by the establishment, very fearful of contamination, very fearful of contagion, which are classic elements of moral panic. So you have, in other words, in the COVID crisis, you had moral panic and conspiracy theory on both sides. Well, so far, I have not talked about the conspiracy theory, moral panic, and race in the Chinese Exclusion Act. That's where I'll focus next. And the United States is characterized by a deep racism that goes back, I think, to the 17th and 18th centuries, to slavery, to the idea of manifest destiny, the desire to conquer and subdue the West, the frontier, with concomitant war waged against the indigenous peoples of North America. And so you had in the 18th, 19th centuries, running into the 20th century, a deeply embedded racism. This racism plays out in the form of moral panic. I point out in my paper with Native American captivity stories, namely white persons who might be abducted or who might sometimes voluntarily join Native tribal society, leading to all sorts of moral panic on the part of whites and white settlers, the white establishment, very often expending tremendous resources to look for persons who might, in some instances at least, be quite happy in their new surroundings. And you also have, particularly in the early 20th century, you have a tremendous explosion of what race riots, they've been called, groups of whites, usually provoked by some kind of moral panic, to engage in pogroms, if you will, of African American communities. And I identify in the paper half a dozen or so of these events in Atlanta, Springfield, Illinois, East St. Louis, Tulsa, Oklahoma is the most famous of these events, often prompted by allegations of racial sexual mixing. Often black men involved sexually with white women, and this would lead to white people seeking to avenge this outrage, this perceived outrage on the black community of a given metropolis, and leading to the destruction of black communities all across the nation, as I said. In a number of American cities across the nation. Well, that's so now we see we've gone through moral panic. We've looked at the question of moral panic, conspiracy theory, and race. Now let's bring it to specifically to Chinese immigration, which began in serious numbers in the mid-19th century. And you had a steady influx of Chinese moving into the western United States, particularly California, the Pacific Northwest. 160,000 Chinese immigrants entered the United States and settled in California between 1850 and 1875. And this leads to unrest. This leads to signs of racism. But what really sparks the crisis in the Western United States is the depression that is triggered in 1873 with the collapse of Jay Cook's business empire, leads to a panic on Wall Street. And that panic on Wall Street leads to all sorts of labor unrest. This labor unrest manifested itself, particularly in California, as deeply racialized labor unrest, attacks on the Chinese communities of California, and this then leads to the emergence also of a whole body of literature known as the Yellow Peril literature. I go into some detail in the paper regarding the Yellow Peril literature, but there's tremendous fear that the Chinese, because of their perceived large numbers, in fact, their population never that large, but perceived large numbers, would swamp the United States and turn the United States into a Chinese nation where whites would be the minority. So you have this tremendous fear. This leads then to exploitive politicians. taking advantage this percolating mix of racism and fomenting the conspiracy theory. A figure I plays a central role in my paper is James G. Blaine. Blaine is an important figure in late 19th century politics. He serves twice as Secretary of State, Speaker of the House, leader in the Senate, the Republican nominee for president in 1884, and also one of the principal sponsors of the Chinese Exclusion Act. And his versions of the Chinese Exclusion Act are so extreme. In fact, President Chester Alan Arthur vetoed the first version of the Chinese Exclusion Act because of its extremeness. But as adopted, it nevertheless was tremendously extreme in the way it banned entry into the United States of people of Chinese heritage. And I've not yet written the section on the birth of birthright citizenship. That would be the final section of this paper. I see that I'm basically out of time, so I will leave that to later discussion. Thank you all.
At this time, I'll welcome our last speaker of the panel, Jennifer Safstrom.
Hi, everyone. Thank you. Thank you so much for the opportunity to be here today and for all of the hard work everyone has put into organizing such a wonderful event. Unfortunately, from my view, I can't see the full room, but I first wanted to take a quick survey and hopefully someone can report back aloud. How many people are on TikTok? Who has TikTok? Is there a...
about two-thirds.
Two-thirds? Okay. So then this really applies to you in terms of thinking about whether you will have access to this platform moving forward. But even for those that do not have the TikTok app themselves, I think it raises important questions about the First Amendment and separation of powers and other issues. So this matter really came to the forefront in March of last year when then President Joe Biden gave TikTok's parent company, ByteDance, 9 months to either sell TikTok to a US approved buyer or face a total ban of the app in the United States. The ban was a result of concerns regarding the app's potential threats to national security, particularly the harvesting of user data, but also had potential viewpoint implications because of some of the specific concerns raised about what content was on the app. TikTok did not want to sell and fought this effort. And it resulted in a Supreme Court decision on one of the quickest timelines I've ever seen, upholding the January 19th ban on January 17th, which was right before President Trump's inauguration on January 20th. So in the midst of all of this, the app went dark for about 12 hours before statements by then still President-elect Trump made via Truth Social that there was a planned executive order following inauguration to extend the time period at issue for the ban to take effect. So, and that is indeed what happened on his first day in office, issued an executive order delaying the implementation of the ban for 75 days and instructed the Attorney General not to take any action to enforce the law. And most recently on April 5th, actually extended that timeline again until June 19th. So I want to talk through, hopefully today, quickly, both a timeline of slightly more detailed timeline of what occurred, really talk about what some of the arguments back and forth were, what the Supreme Court's decision were, and where some of the existing points of controversy and ongoing questions might be. So in September of 2017 is when TikTok launched on the international market. Within 2 years, there were already concerns by different federal agencies about data sharing and data collection on the app. So for instance, in February of 2019, the Federal Trade Commission fined ByteDance for almost $6 million because of data collection of information of minors under the age of 13, which violated the Children's Online Privacy Protection Act, or COPPA. And ultimately, they reached a consent decree, but that only was the beginning of many concerns that were raised about the amount and scope of data being collected. So, for instance, in 2020, the Wall Street Journal was reporting that it was tracking the data of Android users, including MAC addresses, which was a violation of Google's policies. Additional reporting later on by other entities, including BuzzFeed, showed from TikTok meetings, showed that there was kind of master administrative access that allowed employees to be able to see into the data of overseas users. And much of this kind of led to, in June of 2021, then President Joe Biden signing an executive order in order to have the Secretary of Commerce investigate TikTok and determine what the national security implications were. So what this resulted in was ultimately, in March of 2024, legislation that was passed by a bipartisan Congress and then signed into law by President Biden, demanding that ByteDance either sell to an approved buyer within 9 months or face a total ban within the US, which meant there were severe penalties, including for marketplace platforms that made the app available, and had a by user fine for every day any individual user was permitted to use the app that could quickly total into millions, if not billions of dollars. In December of 2024, the DC Circuit Court determined that this legislation was in fact constitutional and could go into effect in January as anticipated. After that decision, also in December, the Supreme Court announced that it would hear arguments and receive briefing on why TikTok should or should not be sold or banned in the US and what the implications were, including on First Amendment issues. This resulted in some very, again, quick action in consideration of arguments that resulted in a decision being issued on January 17th, just 2 days before the legislation was supposed to take effect, and the US Supreme Court ultimately ruled that the legislation was constitutional and could take effect. As the final deadline approached, on again the day before inauguration, there was a short time during which TikTok actually shut down for about a 12-hour stretch before agreements with the new administration could be reached and public promises made about non-enforcement of the legislation in order to allow for TikTok to continue. And then, as I mentioned, on first day in office, President Trump signs an executive order delaying the ban for 75 days and instructing for non-enforcement. And just as that 75-day window was set to expire, on April 5th, President Trump announced another 75-day extension, making the new deadline for action under this legislation June 19th. So there is a lot to talk about, both in terms of kind of the history of how this developed, but also what its implications are. First, I want to start off by noting that this is not an issue that has a clear partisan divide, which I think makes it especially interesting. Trump himself has had different positions. In his first administration, had been supportive of legislation limiting TikTok and its reach. But then, as including in his Supreme Court briefing on this issue, it was noted that as incoming chief executive, President Trump has a particularly powerful interest in in and responsibility for those national security and foreign policy questions, and he is the right constitutional actor to resolve the dispute through political means. So President Trump's own position on TikTok has changed over time, but that is also reflected both, again, in the bipartisan Congress that passed the legislation, but also in some dissent. So, for instance, Senators Markey, who's a Democrat, and Senator Paul, who's a Republican, urged Biden, even before the Supreme Court took up the case, to delay implementation of the law. On the flip side, Congressman Griffith, a Republican, said, I am glad to see that this law was upheld today, and it is integral to protecting the U.S. By preventing certain foreign adversaries like the Chinese Communist Party from owning and controlling social media and smartphone applications like TikTok in the United States. Similarly, Tom Cotton, a Republican, said that this isn't just TikTok isn't just another social media platform. TikTok is a Chinese communist spy app that addicts our kids, harvests their data, targets them with harmful and manipulative content, and spreads communist propaganda. Similarly, there's been mixture amongst Democrats, including several who voted for the TikTok bill but are still using the app themselves. And this includes Representatives Kasten, a Democrat from Illinois, Jeff Jackson, Adam from North Carolina, Adam Schiff from California, Colin Allred of Texas, among others. And so you see that there is both a divide between folks, not only in terms of political affiliation and how they feel about TikTok, but also their own use with respect to the legislation. In order to consider a First Amendment challenge, we generally look kind of at two prongs. First, is there a compelling or sufficiently compelling government interest? And is it sufficiently well-tailored or narrowly tailored to achieve those ends? So TikTok argues primarily that there is first inadequate evidence to really substantiate any purported concerns about the security of the app, and that the concern about influencing public opinion is one that is not sufficient. To cooperate, that is not required to show narrow, that is not really a sufficient interest. Concerns about what types of content Americans are absorbing is insufficient to justify that concern. Narrow tailoring means that, is this really related? TikTok points out not only the fact that it was targeted, but to the extent that this might be too narrow. If the concern is really about Chinese data collection or data manipulation, the movement toward other apps, including Red Note, which became popular as the possibility of this ban came into effect, was deemed potentially even more concerning, that there was much more control over the content that was available on the platform, including about human rights abuses against the Uyghurs by the Chinese government, and that the terms of service were even more expansive than TikTok, permitting data collection on audio, video, energy, scrolling patterns, and other types of uses on the platform. On the other hand, the government basically said there are two issues: users, data, privacy, and that this is the most restrictive means to prevent TikTok from, with its following and the number of users of the sites on the site, was the narrowest way to achieve these ends. The Supreme Court ultimately agreed that this served an important government interest in protecting national security and was narrowly tailored, imposing the ban or allowing for divestiture as an alternative, such that it comported with any First Amendment concerns. Justice Sotomayor in particular made sure in a concurrence to underscore that this was an act that certainly implicated the First Amendment, but in the per curiam, but agreed with the remainder of the per curiam opinion that the act survives even the strictest of scrutiny under the First Amendment. Why is this controversial? First, this has huge impacts for individual users and commerce. In particular, the popularity of TikTok has increased while the public appeal of a ban has decreased. Per data from Pew, support for a TikTok ban was 34% between kind of the February-March 2025 timeframe, as opposed to over 50% in March of 2023. And the number of people who think that national security is a true concern through the app has decreased from 59 to 49% within the same window. TikTok is a leading source of news and has surpassed Google as a leading search engine for younger users. And there are also concerns and arguments that despite whatever actions Trump has taken, because the statute has a 5-year statute of limitations that runs 5 years, action after his administration could still be taken. In terms of separation of powers, which I think is the biggest issue, is that Congress enacted in April, or when it first enacted the law with bipartisan majorities, that was a clear congressional signal of interest, and there has been no successful effort to either extend the deadline or amend the legislation since then. Both, again, the DC Circuit and the Supreme Court, and I'll note on the DC Circuit, it was bipartisanly appointed panel with both Republican and Democratic appointees in a unanimous opinion, and the Supreme Court's per curiam opinion that really demonstrate concerns over this issue, and the fact that the statute of limitations actually passed before then Trump took action raises some questions, both kind of about the separation of powers and the ability of the executive to essentially override the considerations of both Congress and the courts. There's a lot of lack of clarity of what comes next, particularly because of the tariffs that have been placed on China recently. And there are a number of potential buyers that have purportedly been interested, including Amazon, Microsoft, venture capital firms, Oracle, among others. My last point will be that if there is a version of ownership that includes ownership or a stake by the US government, that could raise a whole other set of First Amendment concerns and interests. For instance, in the case LeBron versus National Railroad Passenger Corporation, the Supreme Court held that Amtrak, which was wholly owned and operated by the federal government, was subject to First Amendment restrictions, as any other federal actor would be, in decisions about what billboards to host or to allow for advertising. So an individual who had rented a large billboard at Amtrak's Penn Station, it was critical of a private company for support of the Contras in Nicaragua at that time in 1995. Amtrak had turned down the ad because it was political. And ultimately, the court ruled that because the determination about the display of that ad was based on the viewpoint it contained, because it was a government-controlled, albeit for-profit entity, it was not permissible, and that viewpoint neutrality requirements had to operate. And so query whether in a world where TikTok has the U.S. government as a financial stakeholder would look and operate very differently if First Amendment protections were to attach. So I'll go ahead and pause there, and I welcome any questions, but just to say in short that I think this is a question that not only raises incredibly important First Amendment considerations, but also more broadly kind of separation of powers, who the right decision maker is, and how that timeline, the way that the timeline ended up coming to fruition, whether or not that was already an early signal from this administration about deference both to either the congressional branch or the judicial branch in these bipartisan determinations that were made. So I welcome questions and thank everyone again, both for the opportunity to join and to learn from my fellow presenters.
I have questions for each of the panelists.
Yes.
Can we start with that?
Yes, all right. We're going to start with Professor Reed's questions for the panelists. So if you guys want to turn on your cameras, and then we'll go into the Q&A with our students as well. Thank you.
I'd like to say thank you all for some wonderful presentations. And I have questions for each of the panelists. So let me begin with my questions, and then you all can take it from there. Mohammed, I'll begin with you. Your presentation, it was a very wonderful presentation, very important presentation that I think plays up, it features American polarization, political polarization. And when I look at minoritarian judges, as you described them, what I see really is the red state, blue state divide that characterizes American politics playing out in the judicial sphere. Judges confirmed primarily with red state support are simply lack appeal, intuitively, empirically lack appeal to the other side of the polar divide. And so perhaps it's not surprising that they are ideologically more extreme. To you, Mohammed, I would like to ask you to relate your presentation to the underlying phenomenon we see of American political polarization. And Sarah Oakes, thank you again for your presentation on the International Criminal Court. And let me ask you this question. Is the threat to the International Criminal Court really a narrow threat posed by Donald Trump, or a larger problem with the reemergence of a robust great power competition? Great power politics, of course, was characterized in the 19th century and geopolitics up through World War II. The Cold War sublimated some of this, and the American hegemony that followed on the collapse of the Soviet Union in 1991 also had the tendency to submerge great power politics. What we're really seeing now, I think, is the reemergence in the 2020s of great power politics. And it's only natural, you would think, that the great powers, the so-called great powers, Russia, China, the United States, would exempt themselves from the International Criminal Court because they're the ones committing the war crimes, right? Great powers tend to immunize themselves. And perhaps it's not surprising. It's a lamentable, predictable phenomenon that we would see prosecutions concentrated in Africa while the great powers exempt themselves. Russia commits war crimes. The United States is alleged to do this. China hasn't had a war recently, but I can understand it's certainly explicable from these terms to see China exempting itself. So is the problem, Professor Oakes, really a problem with great power politics? And Jennifer Safstrom, if I could ask you, is TikTok, the competition over TikTok, really a proxy for two competing interests? First, a domestic desire on the part of President Trump to remain politically popular, especially because he's doing some very unpopular things, and he doesn't want to do one more unpopular thing by shutting down TikTok. TikTok is a popular app, and its loss will be felt. But at the same time, there's also the countervailing fear of China. And when I hear someone like Tom Cotton say what he does, I'm reminded of the Yellow Peril literature I've read from 125, 130 years ago. But if matters with China deteriorate, then I think it may almost be predictable that TikTok will fall victim to what I think is geopolitics. So let me ask you, Professor Safstrom, to what extent is the TikTok controversy really a proxy for these two competing countervailing trends? On the one hand, a president's desire to remain popular, on the other hand, the pressing exigencies, if you will, of geopolitical competition. Thank you all, and I look forward to your responses.
Yes, thank you for the question. One of the things that we could do to expand this study, and I might be willing to do, is to do the study with Democratic president and see whether IPV as a continuous variable could also have an effect on Democratic appointed judges. For example, if there are some Republicans voting in favor of a Democratic nominee, uh, um, how that would count and whether that would moderate the ideological opinion of a judge or not. So what I would say is that um, when it comes to minoritarian judges, at least I would say minoritarian judges are phenomenon of like President Trump. It could be attributed, as you well articulated, to the controversial hearings, controversial confirmation hearings. It could be attributed to political divisions among Americans, uh, or it might be attributed to um, more ideological extremist views of these judges. But like what my contribution would be is that at least minoritarian judges phenomena is a recent phenomena, and second, that minoritarian judges happen to be more ideologically polarized than the majoritarian judges. So that ideological polarization might be a contributing factor for the fact that senators didn't vote for them in the first place, or the political division itself might be a factor as a rise to minoritarian judges. But you're also absolutely right to point out that red states have less popular vote, but I would say most of the difference between minoritarian and majoritarian judges are not made by the red states when it comes to Trump administration, because basically red state senators all voted for both categories of judges. But for the certain blue states, some Democratic senators who shifted voted for particular judges and didn't vote for the other judges, and that gave rise to majoritarian judges and minoritarian judges. And for me to be able to find the ideological difference between those categories. And thank you for your question.
No, thank you. Professor Oakes.
Excuse me. Dr. Reed, thank you so much for your question. You really kind of hit the nail on the head when you were asking, is the US a narrow threat, or is it part of a greater problem of great power politics? And that's exactly what it is. It is one part of a much broader problem that the ICC is facing and that international criminal justice is facing as a whole, which is this idea that international criminal law, international criminal justice has really, since its inception, been hindered by this problem of double standards. And I think from my perspective, the year of 2024 was like the year of double standards in international criminal law. It was discussed at so many conferences throughout the world and throughout the country. And to my knowledge, there hasn't really been a clear solution to it yet. And that is why we are, suddenly or not so suddenly, seeing so much pushback from the United States, from Russia, from Israel against the ICC and international criminal law generally, because this is finally the time that the ICC and international criminal law has been kind of working to rectify the double standards that have been so present in its operations so far. So as I mentioned, and as you touched on, up until 2017, the investigations that the ICC was conducting were primarily focused in Africa. Those nations don't hold so much power, relative power, on the geopolitical scale. The ICC prosecutors really tried to, I think, or really tried to correct the problem, and in doing so kind of overcorrected the problem by saying no longer are we going to focus on just those countries that don't hold so much power. We're going to go after the big guns. We're going to go after Russia. We're going to go after the US. And we're going to go after Israel. And in doing so, it's really resulted in this level of backlash. And I'm not entirely sure what the solution is to that, if we will ever be able to kind of overcome the double standards in international criminal law. But the backlash that we are seeing now, both from the US and from these other great superpowers, it's not entirely unexpected. I think many of us kind of in the field of international law did see this coming. So you definitely touched on a bigger problem. So thank you.
Thank you.
Thank you so much for your question. I will say that in addition to, I think, the potentially competing interests of political popularity and geopolitical competition, this is also a proxy for just the government trying to figure out what its relationship should be to both speech and online platforms and speech on online platforms. And there have been a number of cases from recent Supreme Court terms that really seek to expand into some of these areas, and I think, again, raise only further questions. So, for instance, from last term, a case called Linky v. Freed was determining when there was a sufficient state action such that First Amendment protections applied when state officials were engaging in speech on public platforms, and whether or not they could, for instance, based on viewpoint, remove users or comments from those spaces. In Gonzalez v. Google, there was discussion about what is the appropriate scope and application of Section 230. In Murphy v. Missouri, questions about what the relationship could or should be between government and putting pressure on social media entities about changing messaging, including related to the COVID-19 pandemic. And those are all just some of the fronts on which I think this battle of government speech online platforms, and also more broadly kind of data security and privacy are taking place. And so I certainly think the tension between political popularity and political competition is core to that assessment. I also think this is representative of a much broader discussion about what the appropriate relationship and balance between all of those different entities should be. And that's one that's true across branches, both from the legislative, executive, and judicial angle, and how we should be navigating these rights, especially on emerging technologies.
Thank you.
All right, with that, we'll take questions from students. If you have any questions, feel free to raise your hand and we'll walk around with a mic.
Hi, my name is Alex Singer. First of all, I want to say thank you so much. They were fantastic presentations. I had a question for Professor Oakes. I was wondering, your presentation was on whether or not the ICC could survive, and ultimately you came to the conclusion that yes, but I was wondering, what would it look like in kind of real time of if it didn't survive, or it was dying in a sense? Would it be that the countries that are signed on to it would just not heed what they've heeded before? Is it that, we talked about these great powers working against it, that they would take stronger action against it? I just kind of wanted to hear what you were looking at in terms of coming to your conclusion.
Thank you so much. That's a really wonderful question. And I think the death of the International Criminal Court, not to sound too dramatic, could potentially take a number of different forms. And one is very much what you touched on, is something like a mass exodus of states parties to the Rome Statute. There have been a few countries recently that have withdrawn for various reasons. The Philippines withdrew. Hungary has recently withdrawn as well. We have not seen something like a mass exodus with dozens of states parties withdraw and come to fruition, but that's never off the table. I think another kind of image that I'm seeing as far as the ICC's lack to survive is just essentially it's inability to conduct investigations, being blocked, not only, in some of these more high profile cases from being able to successfully investigate and prosecute, but from some of the other cases that have flown a little bit more under the radar in international media and national media. So cases that are still ongoing against countries like the Philippines and various countries throughout Europe and in Africa as well. So I think just, no longer being able to conduct effective investigations or conduct effective prosecutions and slowly, I think it would be something like a slow death in which the court just could no longer fulfill its mandate. So I do think that it could come in several different forms. I'm very hopeful that we won't see any of those. Fingers crossed.
Hi, my name is Stephanie. First, I want to say thanks to all the speakers. I really enjoyed all your presentations. My question is for Professor Reed. I think recently we've seen a lot of growth in panic, especially with all the tariffs that have happened. In looking at all your research, have you found any successful path that has soothed moral panic or reduced it in any cases?
Oh, that's a good question. I think I'm not aware of empirical research on that, but I can give an educated guess that what would help with moral panic is two things really: some education, learning that there is there's always a larger truth out there that we should be aware of, and then secondly, I think not to jump the gun, just kind of keep an emotional stability as opposed to running off in a panic. But panic, takes place on an individual basis. It also takes place on a social basis. That was Stanley Cohen's point, and I think he demonstrates it fairly well. And so panic is an emotion-driven response to something we see that has a rational explanation. We should try to understand the rational explanation. We should understand as a society, the United States, that we're a big country, that we are not threatened. I think, the most threats out there we tend to view with a kind of exaggerated sense of fear, but I don't think that's justified. Emotional stability, a sense of emotional security, sense of well-being, and some better education. I think those would be the elements that would help solve the problem. Thanks.
Hi, everyone. My name is Nate. I want to echo what everyone said about the presentation so far, and thank you all again for being here. My question is for Professor Oakes. You mentioned that one of the ways that the International Criminal Court could increase its, viability is through better prosecutorial strategy. And I'm wondering if you think that would be able to overcome, kind of the relatively, toothless enforcement mechanism of the International Criminal Court, being that it's entirely dependent on domestic law. And if those nations aren't willing to, play ball, how that strategy could overcome that.
Thank you so much, Nate. That's a really great question as well. I am hopeful that maybe a shift in prosecutorial strategy could at least prove effective for the court in really improving its outward narrative and presenting itself as kind of a formidable opponent to both states parties and non-states parties. What I am kind of envisioning in this shift in prosecutorial strategy is, as I kind of mentioned when I was responding to Dr. Reed's question, really what we saw was this great pendulum shift at the ICC, in which it was originally focusing on just kind of these African conflicts. That was it. These maybe even individuals within those conflicts who were not high-ranking military or governmental officials or heads of state or anything like that into really just going for the biggest fish possible. Arrest warrants for Vladimir Putin, arrest warrants for Benjamin Netanyahu, sitting heads of states of these global superpowers. So what I am thinking as far as a prosecutorial shift and what I am suggesting in my paper is that we kind of bring the pendulum back to the center a little bit. So not only is the ICC going to be focusing, maybe there is a handful of cases that deal with African nations or deal with nations that, don't hold great geopolitical power. Maybe there's a handful of cases on the opposite end of the spectrum that address alleged crimes committed by superpowers, but really we are focusing kind of somewhere in the middle. So on conflicts that have secured international attention, and include, potentially controversial conflicts, but ones that at the same time convictions are obtainable. So is in situations where the ICC may have the state cooperation, may have the support that they need for the prosecutor to conduct sufficient investigations and achieve potential convictions. I think by, being able to acquire just quantitatively more convictions, it will give the ICC more legitimacy. So I think there needs to be a balance in between those, high-reaching, controversial cases, as well as those more obtainable cases, if that makes sense.
All right, we have one final question here, and then we will start our break.
Again, echoing the sentiments of everyone who's spoken before, thank you so much for taking the time to speak with us today. My question is kind of a follow-up to Professor Oakes based on your commentary. I know we're focused on Trump and his impact, but no US president has signed on to the ICC. Do you think that it would make a tangible difference if it was, say, a Democrat in power or someone who has even leaned more heavily in their support to the ICC, if they continue to make these controversial actions? Like, I don't even think Biden would have, I think Biden would have reacted in essentially a very similar way to Trump with the Israel declaration. So I'm curious to your thoughts on that.
That is another wonderful question. Thank you so much. I do not think that it really makes much of a difference whether we have a Democratic or a Republican president in power. The United States, I think, has made its position very clear over the last 20 plus years that we will not be joining the we will not be joining the ICC. I don't think really there is any hope, regardless of who our president is, of the United States really ever becoming a state party to the ICC. And you are completely correct. Joe Biden was very, very against the ICC's investigation into Afghanistan. It was made its point very clear that it was anti-investigation into Israel. And that is under a Democratic president. Obviously, we've seen even more kind of vitriol, if you will, of Trump's handling and approach to the ICC. But I do think that we will never, pessimistically, I don't think we will ever see a day where the US president is willing to sign on to the ICC until at least there are significant changes.
All righty, thank you so much to our panelists. If we can give them one more round of applause.
Okay, we're going to get started on our second panel focused on trade, tariffs, and the future of economic policy. This panel examines the shift in U.S. trade policy from free or managed trade to aggressive neo-mercantilism across the Trump and Biden administrations. Panelists will explore continuity and change in tariffs, non-tariff barriers, and trade sanctions, along with the broader implications for economic nationalism, the Tax Cuts and the Jobs Act, and the U.S.-China trade tensions. Additionally, an analysis of Adam Smith's critique of reciprocal tariffs will provide historical context on the long-term impact of protectionist policies. Our first panelist, Raj Bala, though unable to join us today, will have his paper presented by Charles Reed, Professor Reed. Raj Bala holds the inaugural Brunesian Distinguished Professorship at the University of Kansas Law School, where he teaches international trade law, law and literature, and Islamic law. He has taught around the world. He is a Fulbright specialist and a member of the State Department Speaker Program. Ingram's Business magazine designated Raj as one of the 50 Kansans you should know, and he is wikified. Raj practiced international banking law at the Federal Reserve Bank of New York, where he twice won the President's Award for Excellence for his service as a U.S. delegate to the United Nations Conference on International Trade Law. Raj graduated with his JD from Harvard Law School in 1989, completed his master's degree at LSE and Oxford Trinity College as a Marshall Scholar, and did his undergraduate degree at Duke University as an Angier B. Duke Scholar. Raj is an active member in the London-based International Bar Association, including serving in officer positions, as well as in the Tokyo-based Inter-Pacific Bar Association, London-based Royal Society for Asian Affairs, and New York-based Council on Foreign Relations. Our next panelist is Enrique Guerra Puyol. Puyol attended college at the University of California at Santa Barbara, graduating with highest honors, and received his JD from Yale Law School. After practicing business law for several years, Professor Guerra Puyol began his academic career at Pontifical Catholic University of Puerto Rico. He is currently teaching at the University of Central Florida. His recent work focuses on the life and ideas of Adam Smith, including his works Adam Smith and the City of Light, forthcoming in the Adam Smith Review, and Adam Smith's Blind Spot, forthcoming in the Journal of Public Finance and Public Choice. In addition, his research spans multiple interdisciplinary areas, including law, economics, philosophy, and probability. Our next speaker is Doran Naratsky. Doran Naratsky is the director of the Master of Taxation program and an associate professor of taxation at the University of Akron. His research focuses on international taxation, corporate tax, public policy, and the intersection of tax law with economic and legal theory. Professor Naratsky's scholarship has been published or is forthcoming in leading journals, including the Texas Law Review, Virginia Tax Review, Florida Tax Review, American University Business Law Review, Virginia Law and Business Review, Ohio State Business Law Journal, Georgia State Law Review, and University of California Law Business Journal. Professor Naratsky frequently presents his work at international and national conferences and has been invited to speak at institutions throughout Europe, the United Kingdom, and the United States. Our last speaker on the panel is Ziyi Wang. Professor Wang is an economics PhD and JD candidate at Cornell University. Wang holds a Bachelor of Science in Foreign Service from Georgetown University. Wang is a research associate at the UN 75 Global Governance Forum and a member of the Legal Research Evaluations Working Group at the UN Journal. Please join me in welcoming Professor Reed to begin on behalf of Raj Bala.
Well, thank you for that very kind introduction, and I will begin by mentioning I'm standing in as a surrogate for Professor Raj Bala. I'm both honored and humbled to be asked to serve as a surrogate for Professor Bala. He is truly a giant in the area of international trade. I'll begin by reading the abstract to his article and then highlighting several features of his article that I find particularly compelling, knowing that I'm not doing justice to the entire piece because there is so much richness in the article that I cannot do justice to the entire piece. But I'll begin with the abstract. This article analyzes one aspect of the dramatic shift in multilateral, regional, and U.S. trade law from free trade, or at least managed trade, to an aggressive neo-mercantilism. The article argues that this economic shift enjoys broad bipartisan support through export control regulations during the Biden interregnum, and the first 100 days of the second Trump administration, the U.S. has consistently sought global production and export dominance in advanced artificial intelligence semiconductors. America's strategic goal, shared across the political aisle, is to impede the People's Republic of China in its aspirations to develop sophisticated microchips of their own. Simply put, restrictions, actual or proposed, on the cross-border flows of advanced AI chips to a small number of preferred countries illustrates industrial policy through export controls, which in turn is a hallmark of America's aggressive neo-mercantilism. To be sure, through its multiple new tariff regimes and threats thereof, the second Trump administration has been yet more aggressive than its predecessor in attacking the multilateral trading system and free trade agreements. Its end game for its attack on the GATT, WTO, and NAFTA regimes seems to be xenophobic autarky, and that outcome does not enjoy broad bipartisan support. But what is common across administrations, regardless of their political party, is a concern about the diffusion of national security-related technologies to adversaries. That concern, though not necessarily the specific export regulations that manifest it as it should be. So in other words, let me summarize that, and that is Professor Bala contends that the United States abandoned, sometime in the 20-teens, on the basis of broad Democratic and Republican support, abandoned a commitment to free trade in favor of what Professor Bala terms aggressive neo-mercantilism, the targeting of one nation in particular for all sorts of export restrictions, that nation being the People's Republic of China. Professor Bala points out on page 4 of his paper, my argument here is that consensus reigns in this highly technical area of U.S. international trade law. The consensus is in favor of export controls. Export controls, Professor Bala contends, are crucial in how America views its relationship with certain countries and what its vision is for itself in the global economy. My argument here, then, is that export controls and advanced AI chips are part of American-style industrial policy and illustrate a paradigmatic shift in U.S. trade law. For 80 years, roughly 70 years, from the 1940s to the 20-teens, the United States has been committed to a policy of free trade. And Professor Bala is contending that this approach was jettisoned in the 20-teens and on a bipartisan basis, and in favor of an aggressive neo-mercantilism. This argument, Professor Bala points out, relies on two key concepts, and that is not only that the United States seeks to maximize its trade surplus by maximizing exports and minimizing high-value added imports, but also on a conscious industrial policy that entails subsidies for selective industries, protection for selective industries, and export controls to ensure continued American domination in those industries. And the industry, particular concern is, of course, the emerging industry in artificial intelligence and the sophisticated microchips that support artificial intelligence. The Biden administration was aggressive in promoting this approach, and Professor Bala quotes at length documents from the Biden administration, which I will summarize just very briefly, pulling out a few excerpts. And pointing out that, for instance, NVIDIA Corporation was instructed to halt shipments of artificial intelligence computing chips to China. The same restrictions were extended to other American corporations, the KLA Corporation, Lam Research Group, applied materials. And this was done on an expedited basis through the Commerce Department using what are known as informed letters and sidestepping, in other words, the rulemaking authority of the Commerce Department. Professor Bala goes on to point out that, again, quoting from U.S. analysts, examining now not the Trump administration, but the Biden administration on China, the U.S. has essentially declared war on China's ability to advance that country's use of high-performance computing for economic and security gains. One chip industry executive said the U.S. was, quote, attacking China from all angles. And this executive went on, the stunning thing about this move is that they have assembled a whole array of tools. They are not just targeting military applications, they are trying to block the development of China's technological power by any and all means. This went on from beginning in 2022 into the fall of 2023. In the fall of 2023, a whole raft of restrictions went into place, identifying equipment, microchips, and other supplies placed on a list of controls, export controls, items that would not be exported to China. The Trump administration, the second Trump administration, has, of course, rather theatrically engaged in all sorts of tariff bluster and threats. But focused on China, focused specifically on China, it seems that those, and I'm summarizing Professor Bala here rather loosely, those threats seem to be they're bluster with other nations and half-formed threats with other nations, but with China, a very real and very deep focus. And as we're seeing unfolding last night and today, the United States and China seem to be deeply embedded now in a trade war, the seriousness of which we've not seen in probably 100 years or more, and a trade war that shows every sign of escalating. Professor Bala quite presciently points out that this trade war has Democratic as well as Republican roots and support, although it seems that President Trump has taken dramatic, highly dramatic moves in aggressive ways. Anyways, that's my summary of Professor Bala, knowing that I cannot do justice to his very serious and deep thought here. But thank you all.
Okay, and then we'll welcome our next speaker, Enrique Guerre Puyol.
Thank you. And I really want to begin by thanking Charles and Jenna and the Journal of Law and Public Policy for inviting me to participate in this symposium, which is very, very timely. I also, and which really coincides with my interest in Adam Smith. I should say, by way of background, that my interest in Adam Smith, it was a rediscovery, if you will, byproduct, unintended consequence of the COVID-19 stay-at-home emergency that I joined. In part to pass the time, and in part to piqued my intellectual curiosity, I joined an Adam Smith reading group on the theory of moral sentiments, which is Adam Smith's first great book. And in fact, Adam Smith considered himself first and foremost a moral philosopher. And that led me to my interest. Now, what I'm about to present, and let me see if I can, just to make a little bit fun here, I have some picture prompts that I'd like to share. All right, I think we're in here. Let me see if I can make this larger. I've actually retitled my talk. Initially, I was thinking of just doing a straightforward application of Adam Smith to the tariffs. When I responded to the call for papers, I think I accidentally turned on my transcript, but it doesn't bother me. I've just never seen that feature before. I apologize, caught me off guard. When I initially responded to the call for paper, and by the way, the Dean Kelly's words this morning were very apt. You know what I'm about to say really is, as of 10:30 this morning, there have been such dramatic events, literally not on a daily but hourly basis. On the other hand, I relish this is a great challenge. This is as an academic to contribute to this important discussion. I've titled this a play on words, "The Dearth of Nations," Adam Smith, Donald Trump, and the Dearth of Nations. And part of I just want to make it very clear, although I'm going to play a devil's advocate in this talk, I'm going to use my scholarly prerogative to actually attempt to see what Adam Smith has to say about tariffs. And when I restudied The Wealth of Nations, specifically Book 4, where Adam Smith really delves into the nuts and bolts of free trade, I was discovered to find a very nuanced and sophisticated Adam Smith that could, in theory at least, be invoked to defend the tariffs. And normally we think of Adam Smith, right, as the patron saint of free markets and free trade. So I found this to be surprising, but at the same time very intriguing. So I want to share my research with the audience, and then close with some final thoughts. Now, I want to begin. This is a panel on projecting the legal impacts and policy impacts. Oh, by the way, I have this image here, right? You may have. I was actually, I think there's April 2nd was a Tuesday, if I'm not mistaken, or a Wednesday. No, it had to be a Tuesday. I wasn't teaching that day, so I was watching C-SPAN, the Rose Garden press conference, and some charts were shown, and this is the so-called Liberation Day tariffs, and this is really, actually, it's not unprecedented. Let me just fast forward. As part of my research, the very first major law enacted by Congress was sponsored by none other than James Madison, considered by some historians to be the father or architect of our Constitution, although that consensus is starting to be shaken up. But it was the Tariff Act of 1790. 1789. Signed by President George Washington on July 4th, 1789, specifically with the purpose not so much to raise revenue, although that was one of the purposes of the bill when you look at the history of the original Tariff Act, again, the first major law enacted by the Congress, but to protect domestic industries. I also have a picture of the great Alexander Hamilton here on the left, and many of you may have seen the musical, now that it's on Disney Plus, or maybe you've had the honor to see it live. Wonderful, if you will, reimagining of one of our founding fathers. But I will say with Hamilton is, many of you may not know this, but he authored, a report on manufactures in 1791, in which he proposes bounties or subsidies to promote certain domestic industries, and in addition, additional tariffs. And although the bounty part of the report, the subsidies recommendation, was not adopted by the Congress. Almost all of the recommendations for tariffs in the report 1791 report for manufacturers were adopted by Congress in the Tariff Act of 1792. In other words, what I'm trying to say here is not so much to defend tariffs. This is just part of my research into my paper, but to show kind of 2 points here. One is to kind of understand, well, one has to do with my just fascination with Adam Smith. I teach actually in the College of Business at the University of Central Florida, not in a law school. That was my first teaching gig. And so I consider Adam Smith to really be, if you will, the founding father of the, of business. And so free markets and whatnot. So my interest there has blossomed since my first digression where I rediscovered theory of moral sentiments. But what I wanted to show you here is 2 points that Adam Smith, I have a co-author on another work, Salem Rashid, at the University of Illinois, Champaign-Urbana. And we kind of explore that, Adam Smith didn't really have that big of an impact initially, The Wealth of Nations. It's one of these things that people said they admired, but really didn't read. We see this in the founding of our nation, and the other thing is, to try to understand the popular appeal of these tariffs, which blows my mind. This is going to be the dearth of nations, I think, if you ask me. But then I love this. There's something called the ideological Turing test. And that is to say, if you are a conservative or if you are a libertarian or if you are a progressive or if you are X, Y, or Z, can you, take the argument of, let's say, someone you disagree with, and can you make the argument for them on your behalf so that on their behalf, so that a third party would not be able to distinguish you. Let's say, for example, I'm libertarian, right? I believe in free and open markets. But could I plausibly make a strong argument so that a MAGA acolyte, a strong argument for tariffs so that a MAGA acolyte could not, would not know that I'm a libertarian. So I just kind of want to tell you sort of my intellectual motivation, the challenge here. And I think as scholars, intellectuals, we need to be intellectually honest, So that's why I'm doing this exercise, even though I think at the end of the day, I don't know if I'll be fully persuaded. We'll see what you guys think. I also want to say before I begin, one more prefatory remark. I have here kind of interlaced the Congress and the courts. As far as I'm concerned, I began at the teaching at the Pontifical Catholic University of Puerto Rico. I began teaching constitutional law and a seminar on the Federalist Papers. I have no doubt whatsoever that the President Trump's action on April 2nd, declaring the sweeping tariffs, is completely ultra vires, right? It's completely invoking the International Emergency Powers Act. I just don't think it even passes the rational basis test. But I'm going to be also very honest that I have very little faith in our courts. Very little faith in our courts, that they're going to really reach that conclusion. And I say this, and based on the previous panel, the TikTok case, I thought it was abundantly clear that at the very least, the TikTok bill raised some serious, speech concerns. And normally courts are very solicitous of speech concerns. I understand there were some national security concerns as well. I thought those were more of a pretext, moral panic, to borrow my colleague Professor Reed's earlier remarks. But I was rudely awakened by the TikTok decision. You know what I mean? So I have very little faith that the courts are going to do not the right thing here, normatively speaking, but descriptively speaking, the correct, application of the Constitution. So I want to turn to Congress and discuss the policy debates. And so here, just in my remaining time, and let me just do a quick time check. Let's see. If in the chat, I don't want to go over my time. So I'll try to be brief as possible. I actually forgot to hit my timer here. I just want to let you know that when you read Adam Smith, you're going to find is a very fascinating, nuanced, sophisticated treatment. I really think modern day scholarship just pales in comparison, with just, this is just, and it's just literary quality. But anyways, Adam Smith makes a number of exceptions. He is a free trader, and he makes a very powerful case. I'm a libertarian. I believe in free trade, really because of my exposure to Adam Smith. And the more I read Adam Smith, the more I'm firm. But he does make some exceptions. I want to be intellectually honest, try to defend the tariffs, look at these exceptions, see if they apply. I know this is a sacrilegious case to kind of invoke Adam Smith to defend the Trump tariffs, but I'm going to try that exercise just because I think it's, why do people go to the gym, right? You want to exercise your muscles. All right. So here I have a famous engraving from the Encyclopédie, the great, work product of the Enlightenment. This is Adam Smith's pin factory. And Adam Smith makes a powerful humanitarian exception for trade barriers that are already on the books. If removing them suddenly would cause massive unemployment, massive dislocation. You'll find this in book 4, chapter 2 of The Wealth of Nations. Adam Smith really, and when I go to Adam Smith conferences, one stream of research is that Adam Smith shows a lot of concern for the poor and working people. And but clearly, when you read Adam Smith, when it comes to what I'm calling his humanitarian exception, it just doesn't apply to the Trump tariffs, because Adam Smith makes it very clear that this exception only applies to existing tariffs, existing trade restrictions and trade barriers that are on the books, and don't remove them. Smith is prepared to tolerate them, but when you read him, he says, look, but they need to be gradually and, incrementally removed. They do need to be removed. Just don't do it all of a sudden. He's willing to make an exception if there's going to be mass dislocation. Clearly, it doesn't apply here, because what we're talking about here, right, is a whole bunch of new tariffs, and tearing up old free trade agreements with Mexico, with our, longstanding North American allies, Mexico and Canada. The other important exception that Adam Smith makes, and he cites specifically the British Acts of Navigation, which was the linchpin of the British mercantilist system. Basically, all cargo coming in and out of Britain had to be by English crews, or crews from English colonies, British colonies. And Adam Smith says, look, I call it his national defense or national security exception. That can be very sweeping. You could see how this actually, you can see how I think Trump is trying to, or his advisors are trying to get under this exception by invoking the International Emergency Powers Act, you know what I mean? Saying this is international emergency, this is some tenuous connection here to national security. I really think here that this also is a complete stretch. This argument fails, this is not a really good defense of the Trump tariffs. I agree with Smith, national security is a legit concern. But it's got to be targeted, right? Here I'm just going to use common sense. It's got to be targeted, right? Export control specifically. We're not going to send fighter jets to our enemies, or, sensitive technology, computer chips, those kind of things, right? And I think that's what Smith really had in mind. Although I will tell you, by Smith citing the Navigation Acts, you could say either he was wrong, to invoke national security, or that he was a little bit careless in his empirical example, or maybe there's something else going on. He's writing for an audience, and this, etc. One of the last exception I'll talk about here, I call it revenge. Adam Smith, there's a great quote here, and it's let me just share it with you, the proper site, paragraph 38. Paragraph 38 of chapter 2, book 4 of The Wealth of Nations. Adams is saying, look, when another nation imposes tariffs on, Britain, then, and I quote, revenge in this case naturally dictates retaliation, and that we should impose the like duties and prohibitions upon the importation of some or all of their manufactures into ours. Nations accordingly seldom fail to retaliate in this manner. Again, another example, Adam Smith being very pragmatic, being very realistic here. I will just say about this, one can say, look, this is also a stretch, because these are not really reciprocal tariffs, you know what I mean? But on the other hand, if I'm going to play devil's advocate, I will say that, I think the premise of the Trump tariffs are that, quote unquote, other nations have been ripping us off for years. And even if it hasn't been through explicit tariffs, like they've imposing 10% tariffs on us, the argument is that they're doing it through currency manipulation. There's sophisticated literature on that. That is not an unreasonable allegation. And through non-tariff barriers, and we could go through that. There's a lot of literature on that as well. So to that extent, this is probably the best argument you could make. Now, Adam Smith, and I'll end on this note, he says, look, if you're going to retaliate, it should be with and this is the caveat, he qualifies his defense of what I'm calling revenge tariffs or reciprocal tariffs, as is more commonly known. He qualifies and says it should be for the purpose to open markets. He gives an historical example of a trade war between France and the Dutch, the French and the Dutch. Here, I've had some discussions here with a lot of other my libertarian friends, including Professor Ilya Salmon. He thinks, Smith is wrong about this. Retaliation is just, even if it's a one-for-one retaliation, it's going to just lead to tit for tat. It's going to lead to retaliation on the other side. I'm actually more willing to give Smith the benefit of the doubt. If we look at the retaliation, like prisoner's dilemma, tit for tat, if the shadow of the future is long enough and uncertain enough, maybe there's a space for cooperation. So I'll end on this note that, I want to put it this way. And hold on here. If you agree with President Trump's tariffs, that other countries have been ripping us off for years. And I say this is a big if, because this premise may not be true for all other countries. And if you agree with Smith's argument that revenge tariffs are justified, right? So long as the overall goal is to, coerce the other countries into reducing their barriers, get that end state of, true free trade. And again, this is another big if, because retaliation could actually unleash a tit for tat, very destructive trade war. Then, I'm willing to, this hurts me, physically pains me to say this. I'm willing to give Donald Trump, as erratic and fickle and despotic as he may seem, I'm willing to give him the benefit of the doubt here. On this view, there's, on this devil's advocate view, there is perhaps method to Mr. Trump's, President Trump's madness. So either this ploy is either this trade tariffs, these blanket tariffs, which did go into effect, only the higher ones were postponed 90 days. The 10% blanket rate did go into effect a couple of days ago. Either this is an astute or cunning ploy designed to usher in a new golden age of peace and prosperity, or it is a high-stakes gamble that could blow up in our faces, igniting a destructive worldwide trade war and making everyone worse off, in both the short and long run. Trump has decided to begin his second term with an ambitious but risky venture, a desperate and dangerous gamble whose final outcome is uncertain. Is this wager worth taking? And I will end on this: only time will tell. Thank you for your time and attention. I apologize if I went over. Please take it out of my Q&A time. I just lost track of my stopwatch. Thank you again.
And our next speaker is Doran Naratsky.
Okay, hello everybody. Thank you very much for the invitation from the university and from Professor Reed. What I'm going to talk about is definitely, I'm not going to play devil's advocate, to be fair. I'm going to take full advantage of my academic freedom. And I think my position and views on these issues are going to be very clear. And even from the title of the paper itself, when I call it a gamble, then a gamble is clearly something that is not based on any empirical study, any in-depth analysis. It doesn't mean that it cannot work. Clearly, gambles sometimes work. However, my analysis is going to be based on legal and economic policy, doctrinal analysis, and of course, some empirical fact that we have from the past. My presentation itself is going to be less traditional of what I usually do. I'm going to actually begin with high level of the whole situation, with some conclusions and criticism, and then I'm going to break it to two halves, which are, one is going to be the tariff policy issue, and the second half is going to be the TCJA, the Tax Cuts and Jobs Act from 2017, from Trump first term, because there is a bigger picture on how these two policies and their future interact and impact us as Americans and the global economy as a result of that, because of the role that the US plays in the global economy. So the big picture is quite straightforward. What we have is a president who takes full advantage on his executive power at a level that we haven't seen before, at least definitely, I would say, not in recent 20, 25 years. Trump's approach to the tariff issue essentially bypassed any traditional legislative process, not because he does not have such executive power, but because even in the past, when such policies were considered, then for the economic effect of this, President did work with Congress on that issue. Trump clearly does not, and we can see that from the hectic last 2 weeks. I can tell you that my presentation was ready about 3 weeks ago, and I had to almost daily update it. And that alone shows you how volatile this whole situation is. Tariffs and tax cuts by themselves are essentially two sides of the same economic experiment. Both essentially are framed as a pro-American economic growth policy, but function in a very different way. And in reality, from any economic and legal analysis that I know of, they are conflicted. Hence, that's what turns it into a huge gamble, in my opinion. Furthermore, aggressive tariff policy and deep cuts are, in my views, not necessarily can coexist, because our economic situation as a nation is that, and obviously that's not a secret to anyone, we are very deep into national debt, of course. So tariffs by themselves, more often than not, cause inflation, and as a result of that, they lead to many other economic negative issues. Together with the cuts that Congress literally just yesterday, and I did not have time to update that on my PowerPoint, but yes, just yesterday, the House approved another step on allowing further tax cuts to be extended. These two together essentially squeeze the fiscal space that we currently supposed to be navigating, and it does that from both ends, both from the international trade that impact our national economic trade volume and consumption and so on, and the internal revenue ability to raise taxes from high net worth individuals and large corporations. So the result of all this is very negative, in my opinion, because this is the fast track for structural imbalance. It causes a rising cost, falling tax revenue, ballooning our debt, and all of this together accelerates over time with very little room to adjust our financial and economic course. So that is, as I said, I'm not going to play devil's advocate at all. I think my position on the issue is very clear and obvious already. And now I'm going to try a high level, of course, but I'm going to try to explain what's happening on the tariff avenue and then on the TCJA avenue. So Trump's second term marks an extremely aggressive rhetoric and actions, meaning he does not just talk, he actually applies that, as we have all seen, I think, in the last 2 weeks, which indicate a very strong protectionist trade policy, one that we have not seen in almost 100 years. The last time we've seen something that was close to it was in 1930. And as was stated just before me, currently we have a 10% baseline tariff on all imports. And that can change, of course, while I'm speaking, as we have seen in the last few days alone. But currently that is where we are. We also potentially have higher rates that applying currently also to China. But potentially this will also be for other nations like EU, which is in a huge potential economic strain on us and them, and as a result, the global economy. but also on Japan, Vietnam, Cambodia, and some other countries, but that is still up in the air, and we don't know where that will land in 90 days. The legal base, and that is a very high level, of course, to what is happening now with the tariff, is based on several different laws. One is the Trade Act, the other one is the Trade Expansion Act, and another one is the International Emergency Economic Powers Act. There are a few others, but I mentioned the major one. And altogether, these laws, essentially what they do, they expand extremely broadly the use of the executive power when it comes to trade enforcement. The legal shockwaves from tariffs, as we really saw in the last 72 hours, are humongous. There is no other way to describe this. Trump's action challenges legal norms. He clearly sidestepped Congress and the Constitution. Not to say that he's not allowed to do this, but he is going against the norm and what was expected from such major legal and economic policies. The justification, for the most part, relies on different aspects of the national security excuse. Whether some of these are actually carry some merit, others are extremely questionable. Furthermore, this action undermines and further weakens the WTO and its dispute mechanism, something that already started during Trump's first term, actually continued to a large extent during the Biden term, and at the moment now it is peaking to a level that I personally did not expect when I first started studying the issue of the tariff at an in-depth level during the beginning of the Biden administration. I truly did not think we will be at this point right now. The economic fallout of the tariff is really dramatic. The costs, in my opinion, outweigh clearly any gain for most of the economic sectors that we have. Furthermore, inflation, according to Fed study, 10% of tariff contribute to almost 1% of inflation. It also further results in significant decline in our foreign investments. It caused dramatic supply chain disruption, which I want to remind you come already after historic level of disruption that we had as a result of the COVID-19, which clearly led to issues with regard to that part. And almost in the background of everything that we're talking about, we have over $7 trillion in debt set to be refinanced in the next 3 years. The margin for error is shrinking very fast, because when we say we want to finance our debt, we're essentially saying we want to sell treasury bonds to foreign nations. And we really need to realize and fully acknowledge that in the global financial system, credibility is your currency. What people buy essentially is trust, whether they trust you and your policies or not. That was a very high level of the situation of the tariffs. And on its face, it may sound like it has nothing to do with the TCJA. However, 2025 by itself is a fiscal fork in the road, because the 2017 TCJA had most of its tax break for individuals with a sunset provision at the end of 2025. I oftentimes joke that when it was drafted, I'm pretty sure President Trump thought that he will be out of office after the second term, and that would be somebody else's issue to deal with. However, he is now back and he has to solve this issue. And he has a lot of political weight on it, because one of the things that he constantly used as one of his major economic
Alexa, what's the notification?
One of the issues that he essentially was very proud of was the so-called biggest tax cuts ever given to the American people. As a side note, it was not the biggest tax cut to the American people. That is a factual statement, not an opinion, but it was one of the biggest. So at the moment with the TCJA, what we have is either you let it expire, you don't do anything. The other alternative is you extend it. And the third alternative is that you simply restructure it. The way it currently looks like is Congress is just simply going to extend it. According to most studies, the highest one says that it's going to cost us an addition of $4.6 trillion to our national deficit. The more conservative assessments are 4.4. So obviously there is no real doubt between more liberal and more conservative assessment that it will have a significant impact on our national debt. Historical parallels, the most recent one was the Bush tax cuts. And what we do know is that when Congress or president give tax cuts, extremely rare they actually pull them back because of political reasons, not for economic reasons, which also is an issue. And hence why I was not surprised when Trump and the Republican Party chose to simply extend it. The way I view it is extension of the TCJ is equivalent to an economic explosion of our fiscal framework. Extending that will lead to major fiscal strain. It will cause rising debt servicing cost. I want to remind you all that in 2023, we had a credit rating downgrade, which was supposed to signal the American policymaker that they're on the wrong track. It was only the second time in our history that we saw our credit rating being downgraded. So it was supposed to raise some alarms. Clearly, it did not. And if you want to simplify, the reality is quite simple, is that if we continue down this road, we will simply have less money to invest in the American people, in social program, and in American infrastructure. What we see essentially between the TCJA and the tariff policy, in my opinion, is quite clear. The tariff policy by itself challenges the WTO framework, and I would even say expectation from other countries. It also contradicts the US, Mexico, and Canada trade agreement that was signed at the time, hailed as a huge achievement by President Trump, but now it goes exactly against it. And it also has the potential of hurting our long-term trade relationship with other partners. The tax cut by itself clash with the debt and inflation concern. These two together just simply do not play nice when you have them going on at the same time. So my conclusion on this issue is, I'm sorry, but not very positive. So I believe that trade policy challenges the WTO and the US, Mexico, and Canada trade agreement. I think this is an extremely bad situation to be in. I think the tax cuts clash with the debt and inflation concern. I believe that Trump's second-term economic agenda is not business as usual. This is something we haven't seen in, at the very least, 2 generations. Okay, so 50 years. It is a very high-stake gamble, in my opinion, with potentially irreversible consequences, because you need to understand there is an economic empire on the other side of the globe. Questions that I'm not sure I can answer at the moment is, can the US sustain this economic policy? I'm not sure. I think personally, if I had to gamble, I think we are viewing right now a dramatic shift in the global economic power between nations. And what are the legal limits for presidential power in economic policy? I personally believe the courts will support that, because it is clear that the law allows President Biden to act the way he acts. And I don't see any court going against it. In my opinion, this is very clear. However, it does not mean that many legal suits will not be filed if in 90 days we see those tariffs going back. I just think that they will mostly fail. Thank you very much. Really appreciate your time and the invitation.
Okay, and then our final speaker on this panel is Ziyi Wang.
Thank you so much for Professor Reid and also for the university for the invite. And today I'm mainly going to focus on US-China tariff and its legal and economic implication, and also implication for the global systemic risks of the US-China decoupling. A high level did I share it?
Yep, looks good.
Okay. Because on my okay. All right. Yeah, so a high-level overview is that for the past week, we have been seeing unprecedented escalation of trade war between the two superpowers. In the first Trump administration, we have seen the tariff raise across 14 months. But in the second term, right now, we've seen the escalation in just 1 week. And I have to also, like the earlier presentations, I have to update my slides almost daily. And this brinkship really showed that the two countries have already far exceeded the battles that they waged during the first term. And this disruption to the billions of dollars worth of goods will indeed have a devastating impact on both economies and also the global trading landscape. So let me first go over the timeline a little bit. When we have the United States issuing the tariffs, we have seen this really huge spike, and China retaliates here in just within 1 week. So these numbers, I would argue, are a huge impact in both the stock market and people's confidence in the economy. But the worst impact is that the uncertainty it imposed. It doesn't really matter what number the tariff charged. It could be like 100, 200, but the impact of uncertainty can be permanent on both countries and also the trade partners for both US and China. A couple of political economy rationales behind the tariff include 3 contrasting and competing motivations. So the first one, scholars have been arguing that it's a batter. So the administration wants to introduce tariffs skipping the FDI. And the second one related to tax cut. A tax cut with regard to high net worth individuals may not generate as much revenue to pay off the debt. So a tariff could be used as an argument for raising revenue for the government. And the third theory that we are all hoping for is that it is just used as a negotiating tactics so that it would not disrupt the economy in a really long way. For negotiating tactics, we would ideally want to know what the administration wants to get of all the trade partners. But as of right now, we have not really have a clear idea of what the administration wants, because as the administration rejects the EU's 0 tariffs, it really eliminated the first motivations. And it leaves us questioning about what these 2 roads left us and what the administration wants to get out of the tariff. So the legal permissibility, I may repeat a little bit of the earlier presentation. It is legally permissible under the US law per the Section 301 of the Trade Act of 1974, and also the Section 232 of the National Security, and also the IEPA Act. There have been a case, I think last week, in Florida that the lawyers are trying to challenge the use of IEPA, because IEPA traditionally was trying to address questions related to oligarchies, and it has nothing to do with tariff per se. So the attorneys are trying to use argument and like this to push it even more in front of the Supreme Court and utilize the major questions doctrine to try to fight back on the tariffs. One of the justification for utilizing tariffs is to eliminate all trade deficit. However, I want to argue that from an economics perspective, that this is not a reasonable goal, because as we can see from this Fed chart, the United States has been experiencing trade deficit for almost more than 3 decades. And trade deficit just means that the United States is importing more goods than exporting goods. And it's important to note that the trade deficit, it does not include anything about services where the US has comparative advantage in. So if you consider the services, the United States actually have a trade surplus with China, which is the same with Canada. All the educational services, all the AI-related services are not captured by the goods-related definition with the trade deficit. So even if the tariffs still remain in place, it is unlikely that it will do its job in eliminating all the trade deficit. It will still be there even if the trade deficit is there. And one very clever story offered by Nobel laureates, Professor Solow, is that trade deficit is not necessarily a bad thing, because it just happens because different partners have different comparative advantage. So for example, Professor Solow mentioned that you almost always have a trade deficit with your barber, because you just go there, you pay him or her to get your haircut, and almost always your barber never buy anything from you, right? And that is not a unfair competition. It is just you two have different comparative advantage, and the trade deficit was natural in that case. So as we can see, this justification can be questionable, and it relates back to the 3 rationales behind the tariffs, that maybe the administration is pursuing other rationales than trying to address the trade deficit. So among the US exports and imports, we can see the top 5 imports versus exports are really in different realms, and consequently different industries would be impacted differently, and also across different regions in the United States. So as we can see, China exports to the US is usually in the manufacturing industries, smartphones, laptops, batteries, toys, telecommunications equipment, while the US exports to China usually consists of like agriculture-related, aircraft, integrated circuits, pharmaceuticals, petroleums. So we can see different industries are impacted. And the slides just summarize what I said about the justification of saying trade deficit is the main goal of the tariff does not hold. And the Harvard professor, Brent Neyman, whose research were actually cited in the White House tariff reciprocal tariff calculations, said they got it all wrong, because one of the assumptions this administration made was that the tariff placed on one country won't affect imports from any others, and nor is any implications for exports. So say, for example, right now US has 145% tariff on China. Exports from China will definitely decrease. But this does not mean the United States will not increase its imports from, say, Mexico, right? So the administration was ignoring that there is the dynamic relationship behind all these trade mechanisms. And to summarize the economic impacts, I would like to cite many economic empirical and theoretical research. So to summarize the first terms, trade war economic impact, the United States had a import tariff raised to 16%, and also countermeasures increased to 20%. And the costs were generally borne by U.S. Consumers and importers. And there are substantial increase in the prices of both intermediates and final goods, and dramatic changes to the supply chain networks. And it really took time for the factories to change their supply chains. And there are also reductions in the availability of imported varieties and the complete pass-through of the tariffs into domestic prices of imported goods. So data from 2018 shows that it was mainly borne by the U.S. importers and consumers. Economists also show that the response to tariffs increased in absolute magnitude over time. So for us, the impact of price increase would likely to be felt by summer this year. So in 2 to 3 months, we'll be able to feel the price increase. And it really also takes time for the firms to reorganize their supply chains. So interestingly, another study showed that the import tariff favors sectors concentrated in politically competitive counties. And the model that showed the tradable sector workers in heavily Republican counties were the most negatively affected due to the retaliatory tariffs. So as we already summarized the first term, trade war economic impact, we would like to look further to the second term, US-China trade war economic impact. So the classical trade theory still prevails in saying that consumers and firms who buy foreign products, who buy like Chinese-made products, will lose from the higher tariffs. And there will be the distributional consequences across different industries, sectors, and also across different regions with different specializations. And also we would see imports decrease, exports will also decrease due to the retaliatory tariffs, and price would increase, economic growth will decrease, and unemployment rate will increase. So as we have already seen in Michigan and Ohio, we've seen dozens of mass layoffs just recently. So talking about the global systemic risk of US-China decoupling, we have to look at the long-term risks. So it would include, say, legal erosion, economic recession, inflationary pressure, diplomatic isolation with the partners, institutional decay, and market uncertainty. And also, we may have to consider a realistic scenario for the US-China relationship in, say, 2030s. So going forward, I want to talk about what legislative reforms can do. We may have to rely on both the Congress and the courts. So, for example, for the Congress may consider reform, statutory trade authority, as the Congress is already doing. It's already beginning to issue bills to rename the executive orders. And I think there are also incentives even for Republicans to do that, because introducing some reporting requirements can be beneficial if they consider like for future elections. And maybe they want to rein in on executive orders. So I'm optimistic about what Congress can do. And what courts can also do is that the earlier case I mentioned about a firm in Florida filed a case that sued Trump administration over the China tariff, which are also under the IEEPA Act. So we may want to see how this case go forward and try to see its results and whether it goes to the Supreme Court. So to summarize the fragility of the global economic governance in an era of populist unilateralism really tried to weaponize the trade policy. And it threatens not only the prosperity, but also the cooperative frameworks necessary to address the 21st century challenges. So one of my own idea of how the US-China relationship is going to go forward is that I would expect conversations to be taken place. And I think the main reason this administration is pursuing this tariff is because of the diplomatic tactics, and especially with the Trump administration, they pursued the first phase of trade agreement, but failed to continue with the second phase trade agreement because of COVID hit and change of office. So it is very likely that China and US could have a conversation about how to push forward with the second phase of the trade agreement. I think President Trump will be satisfied with the results of a second phase trade agreement, especially with regards to international technology transfer, IP related dialogues. So that would conclude my presentation, and thank you so much.
Alrighty, thank you so much to our panelists. I'll turn it over to Dr. Reed for his questions, and then we'll turn it over to the audience. Thank you.
And I'd like to say thank you all very much, each of the panelists. Thank you for wonderful presentations this morning. And I have questions for each of you. And I'll begin with Professor Gara Pujol. And that is U.S. tariffs. Why are we seeing U.S. tariffs? I see three possibilities here, and perhaps you see other possibilities here. One might simply be a desire to, there's a historical element here. We are seeing a reversion to Hamiltonianism. Tariffs began in the 18th century, 19th century, as out of self-interested motivation. The United States sought to build an industrial powerhouse. That was Hamilton's vision in the Report on Manufactures, and that was a consistent vision of certainly of the Republican Party, Henry Clay before that, all the way up through the end of the 19th, beginning of the 20th century. And so we saw that as self-interested motivation that actually paid benefits. The United States did become an industrial powerhouse over the course of those 120, 130 years. So number one. Number two, then do we see free trade, which emerged in the 1940s as a steady American commitment? Do we see free trade really as an extension of an American hegemony? The United States won World War II, and having won World War II, the United States was in a position of dominance over much of the world, not all of it. There was the communist bloc, of course, but because of the relative devastation of so much of the world, the United States enjoyed free trade, benefited from free trade because of its position as hegemon. This moves into the third period then, where we see American hegemony at once prevail in the 1990s, but is now seriously threatened. And are we then seeing a reversion to form, a reversion to type, a reversion to historical analogs, the United States retreating to a Hamiltonian mercantilism simply because of a feared loss of hegemony? Is this really the reason we're seeing a desperate gamble occurring here? It is simply a fear of loss. Professor Narodsky, I see again three reasons. You propose that we're taking a gamble, and if I may say, it may be the gamble of a lifetime. And what are the reasons for this gamble? I see three possibilities here. There's a fear of the hollowing out of the United States. Is this an effort to restore a kind of middle-class prosperity that at least is being proposed as one of the motivations behind Donald Trump? Or again, as in my question to Professor Garapulho, are we fearful of a loss of hegemony? Or finally, as you point out, Professor Narodsky, there's a fear of inflation and the national debt, but Donald Trump is a real estate developer, and real estate developers know better than most that inflation is always a friend to debtors. And does Donald Trump see inflation here as somehow beneficial to the national debt? Again, I see all three of these prospects, as you do, as gambles, but do they explain the gamble that Donald Trump is taking? And finally, Ms. Wong, my question to you regards the negotiating tactics. What is the goal of the Trump administration? And let me put this forward as at least a debatable topic. Do we really have a president here, Donald Trump, who has a nostalgic view of the United States, a romantic nostalgic view of the United States? He grew up in a time of industrial supremacy. Does he really want, in his heart of hearts, to recreate an industrial supremacy of the 1950s? I think of Bob Seger, that great political analyst and classic rock musician. The song he sang, we were building Thunderbirds, about industrial Detroit. Does Donald Trump really have beating in his heart this desire to rebuild all the industrial heartland? And is this what he wants? And if this is what he wants, is this at all realistic? And if it's not realistic, where does it go from there? We've certainly seen historically, not in the United States as much as in other nations, politics of nostalgia lead down many undesirable paths. I'll put those questions to all of you. Thank you. Enrique.
Thank you. Thank you, Charles. The questions are spot on. Really makes me, what I love about them, like last time I had the honor of participating and proposing a unconventional, quixotic idea, really makes me rethink. I will just say this. The question of motivation is paramount here. I suspect Trump's true motivation is just the classical, I'll say mercantilist fallacy here of erasing. I agree with Ms. Wong here that, this idea of trade deficits being bad is just, it's such a crazy fallacy. There's just, it's almost feel like, I almost feel insulted. We have to even go back to these basic Adam Smith principles, right? The barber example was very well taken. I mean, if we're going to take this to the ultimate extreme, right, I'm only going to buy goods for my immediate family then, I mean, this is nuts, right? There is, but, we're getting mixed messages here, and I'm giving the president here the benefit of the doubt in that, perhaps, if the true motivation is to encourage other countries to reform their bad ways, eliminate these non-tariff barriers. I will tell you, I'm out of my lane here when we talk about currency manipulation and other forms of, making it difficult for U.S. firms to sell their goods overseas. Ms. Wong is also correct about services. We do actually enjoy not only a comparative advantage, but in some sectors an absolute advantage when it comes to services. And so this is all at risk. So I think motivation is fun. I'm trying to do like an academia, where you try to, as you can see, I love Robert Nozick, and Adam Smith. But if I'm reading about, John Rawls or, the physiocrats, for example, that Smith was reacting to, I want to give them the most charitable interpretation. So to the extent the motivation really is that this is just, and I totally agree with my colleague Dolan here, that this is a really a real gamble. This is why I read, and the stakes couldn't be higher, and one of the ironies here, I think one of the potential inconsistencies when we apply the thought of Adam Smith here, specifically his theory of moral sentiments, his moral philosophy, is would a prudent man take this gamble? And in the last edition of the Theory of Moral Sentiments, which published on the year that Smith died in 1790, he adds an entirely new book or section to the Theory of Moral Sentiments, where he talks of the science of the legislator. And so I really think there is an Adam Smith problem here when it comes to this gamble could pay off if we really do create open markets, and we really reduce these barriers, these non-tariff barriers, and deal with currency manipulation. Then this would be a great payoff. That said, right? That's that big if, right? Is there truly, is that premise really correct? Have we been ripped off? I will just push back a little bit. I think I would push back on with my colleagues here on their panel with Dolan. I would say, look, maybe the gamble is worth taking. You know what I mean? As a Bayesian, I've got to assign 50-50 odds to the motivation question. And I'm going to update my priors. With China, I've been to China. I'm about free trade. But I understand that China, there are some serious concerns about China and how they've treated American foreign business interests in their country, and some other aspects of their trade practices. And while I'm not saying that this is the proper way of going about it, this kind of nuclear option, but I am saying there are some serious concerns here. This is so thank you for the question. On motivation, I really don't know the answer. I'm hoping it's the Smithian one, that the true motivation is to open up other countries' markets. If so, this will be a beautiful gamble. But I'm totally sensitive to the possibility this is going to blow up in our faces and we're all going to be poorer, and maybe the gamble is not worth taking. I'm totally, that is perhaps even higher than 50%. Thank you for the question.
Okay, I will jump in now. It's been a while since I looked into that quote, but if I remember correctly, in 1973, a Democratic senator named Russell B. Long said, he was quoted in Money magazine, and he said, and maybe I'm wrong in one word or two, but he said something like, don't tax you, don't tax me, tax the fellow behind the tree. That is pretty much in my opinion, the motive behind the policy of the tariff, simply because I think most, not obviously the people in this symposium, because highly educated and highly curious about issues, but most Americans simply do not understand the mechanic and the economic and the legal aspect of tariffs. Hence why President Trump can say things like, China will pay. China will definitely not pay. If anyone pays, that's corporations, consumers, and so on. But he never says that, right? He always says China will pay, Europe will pay. Or he says stuff like everyone is ripping us off. It's us against someone else. So it's always this populistic rhetoric that personally, and obviously I'm guessing, nobody knows what goes into one person's mind, right? But I think it is part of the whole populistic rhetoric that not just in the US, but in the world generally has been on the rise in the past, I would say 10 years at least. So I think that is why we are seeing these tools also being executed, because if you ask any objective economic and legal scholar who studied this and went through legal history, tariffs has failed throughout history, whether it was in our original tariff law, which studies show that actually hurt the New England industry, what it was supposed to protect. It completely blew up in our face in the 1930s, and we all know what that led to globally in Europe. in Asia and so on, right? And as for the Trump is a real estate developer, I mean, I'm hoping the president does not consider his own financial interest when he sits with his cabinet member. That's a personal statement, is clear, but I am hoping that. But if we actually think about Trump is not a real estate developer for at least 20 years now. He's selling his brand name and he's getting royalties. So business-wise, tax-wise, he is not a real estate developer for the most part. Most of his business is actually comes from royalties that he sells his brand name. Hence, his brand name is invested heavily in populistic rhetoric that's supposed to speak to the mass, not to us. It's supposed to speak to the person who walks down the street in Cleveland, Ohio, doesn't really know what tariff looks like and how they work. But he heard China will pay. He heard they are ripping us off. That's what they heard. So I think that's what is motivating this, in my personal opinion. Clearly, I'm guessing. I don't know. Nobody knows, but I haven't been sold on the explanation that they have given us, because if you truly believe in your policy, you do not react in the way that you react in the last 2 weeks with these hectic decisions, because as I said in my presentation, our currency in the global economic trade is how people view us. If they can trust us, that we have a real understanding of where we are going. When you constantly, and as I said, in the past 2 weeks, daily, I've updated my presentation and my draft. That is not what brings any confidence to foreign nations who will need to buy our treasury. They need to trust us that we have a plan, a real plan, a sustainable one. So that's what I think, and I am concerned. I think it's a gamble. Can it work? As I said, of course, you can go tomorrow to a casino and become a millionaire with $10 also. But is it likely? Probably not. Probably you're going to end up after 5 minutes with no $10 and poor, as most people who end up gambling everything they have. Thank you.
I will also chime in and try to say thank you, Professor Reed, for the question. Also, I would agree with Professor Narodsky and also Professor Garipolo that there is so many uncertainty right now, and I don't think the real motivation behind the tariff are the political nostalgic motivations. I think it is definitely not realistic going back to several decades in the past. We may have to recreate like a legal like bar on the tariff. We may have to recreate the 1947 Act on tariff limit. But I think the rationale behind the tariff are really unclear to us. When we may have to update our belief as a Bayesian, try to see what the ultimate motivation behind the tariffs are, and try to see if the administration is holding conversations. I know there are like 50 to 70 countries in line are trying to have conversations, and we may have to figure it out in the coming days about the future. Thank you.
Thank you.
Alrighty, we have a few minutes for student comments. Please raise your hand if you have a question.
Hi. First of all, I just want to thank the panelists for the great presentations. They're very interesting and thought-provoking. But my question is about the recent China retaliation. Do we see this continuing as a sort of race to the bottom? Or do we see this, Trump backing down, maybe perhaps like he has with other countries, or does it lead us to a negotiating table? Just kind of what do you see going forward here in the near future? Feel free to answer that.
Well, maybe I will take a first crack at this. And I have a genuine fear that this will turn into a real contest of wills between two superpowers. I'm genuinely fearful that this will be a highly, highly destructive trade war, And we'll be lucky in the end if it just remains a trade war. I think there's great risk here. And it leaves me very, very apprehensive. It's my contribution. Others, please.
I will also jump in and try to see. I think China had a announcement like earlier today saying that it would not try to pursue further. I think that is for the best interest for both. But whether we can come to like a conversation is still unclear to me. But hopefully there will be conversations and dialogues.
I want to second Professor Reed's concerns here about that this may not, this could not only be a destructive trade war, impoverishing both great nations, but also it could lead to a very, it could lead to more dire consequences. In fact, Adam Smith, when he is discussing, he's making a qualified exception for retaliatory tariffs. When other nations are imposing barriers on, in his case, on Great Britain, he gives the example of the Dutch-French trade war, and that actually was an actual real war that precipitated a real war, and it was only after the war that both nations, backed down. And of course, one thing is a war in the 18th century, and one thing would be a war in the 21st century, so it is a very dangerous game, a very dangerous gamble. And I should say, my whole remarks are really, I've been writing a series of blog posts here that later I'll convert into an academic paper. I'm really focusing here on the 10% blanket, tariffs. The China is a special case because not only were those tariffs not postponed, they were jacked up. Now, my hope is, but I have less kind of confidence in this, is that truly, if Trump can get together with the, dictator of North Korea, he can get together with President Xi and they can come to some kind of understanding that this is just another of Trump's bluffs. That's clearly my hope. But is that hope, that's, the left side of my brain says that's probably, a lower than 50% probability. But, it's a possibility. And I hope that's what happens here.
So unlike democratic states, obviously, China has a long-term plan. It's something that they have implemented almost every decade, a new plan that they adjust. I do not think they want to go all in. I'm guessing because they have a long-term plan. I think they already walked into the trade war with a long-term plan. That's why they were extremely quick to negotiate free trade with Korea, with South Korea, with Japan. They're negotiating with the EU. They are already capitalizing on what we gambled on and starting to lose. Hence why they do not need to jack up and go head to head, because one, we are a big economy. They do want to do business with us at the end of the day, but they wanted to strengthen their own global economic position in the world. Hence why they have done it. Why would they keep on gambling when they're already ahead? Hence why I think we are not going to see a trade war that goes all in. I think the responsible adult in the room is actually going to be President Xi, in my opinion, simply because he had a game plan all along, because that's how China operates. And I wish we would have had a 10, 15 years economic plan on how investing and fixing our country. But the price of democracy is that we have a shift in the leadership, and that means different agenda, different views. And yes, we are sometimes making mistakes that can cost us, right? But China has a built-in economic incentive that eventually things stable, because we are a huge economy. It's not going to benefit them. They're also a major bond holders of the US, so they definitely don't want us to see go down and crumble. And they just want to strengthen their own position, which is what I think we will see. I think if we go back and review where we are in 2 years, I think we are going to be more equal partners with China than where we found ourselves about a year ago. That is my estimation and my view of the current situation.
Thank you so much to our panelists. If we could give them one more round of applause before we go into our break. Alrighty, welcoming everyone back from our break. I am excited to announce our keynote speaker, Michael Conklin, who will be leading us in a discussion on Trump's cryptocurrency pivot and the ethical implications. Michael will be exploring ethical concerns surrounding cryptocurrency investment and policy, especially in light of President Trump's recent pro-cryptic shift. His talk will take a utilitarian lens to the topic, weighing the broader societal harms of cryptocurrency, like its environmental footprint, its role in facilitating illegal activity, and the potential for economic instability against its claimed benefits. He'll also take us through the rising political influence of pro-crypto lobbying groups and examine potential conflicts of interest connected to Trump's personal and business ties to the industry. Michael is a visiting professor of business law at Texas A&M University, Central Texas, and lead lecturer at Texas A&M University School of Law. He has been published in over 130 academic journals, including journals in 33 of the top 50 law schools. Michael has completed graduate programs in business ethics, data analytics, philosophy, business administration, and international business law. His industry experience mostly centers around negotiating energy exploration contracts, and his research focuses is expansive but often centers on bridging the gap between theory and practice, providing valuable insight for policymakers, practitioners, and legal scholars. This focus on practical application has led to his placement as a top 20 legal scholar on SSRN. Please join me in welcoming Professor Michael Conklin.
Thank you so much for having me. I'm honored to be here. Actually in Washington, D.C. right now. I just presented at a conference this morning. It's very rainy and dreary. I hope it's a lot nicer where you are. So you're actually going to get a 2-for-1 with me, because I've also written a lot about the self-pardon, the alleged or the potential self-pardon. So we'll go through the cryptocurrency. We got 2 controversial topics, Trump's ties with cryptocurrency, and then his potential ties with a self-pardon. So we should get some great Q&A out of this. Okay, well, just a few years ago, Donald Trump was asked about cryptocurrency, and he voiced what is pretty much my position right now. He said it seems like a scam. He said it facilitates unlawful behavior, and he says it competes against the US dollar. And those are all exact quotes. Well, I think that was at the end of his first term. Well, as he was campaigning for his second term, he turned completely 180. I think he said he's the most pro cryptocurrency president ever, which I guess doesn't say a whole lot because it hasn't been around that long. But he has certainly turned to be very pro cryptocurrency. Maybe first and foremost because he is promoting his own cryptocurrency, and his wife has her own cryptocurrency, of which they have made a good amount of money off of. So this brings about a few very interesting implications and potential incentives and conflicts of interest that he has his own meme coin. There's the issue of foreign influence, in that because cryptocurrency has a lot of anonymity and it's difficult to track, foreign players would be able to simply purchase a lot of Trump's meme coin, thus driving up the price of it and benefiting Trump to a great degree, while it would be very difficult to track. So they could, of course, notify Trump, this is all hypothetical, they could notify Trump, well, we're about ready to purchase a large sum, and then he could confirm that they did on that day. And so it would be a potential way to funnel money to Donald Trump personally to gain influence without having to go through all of the channels and the reporting requirements of making a traditional contribution. Also, and this is a little bit debatable, but to an extent, cryptocurrency is inversely related to the stock market. We'll get into that a little bit later. So it could be argued that, I don't know exactly how much of Donald Trump's wealth is tied up in traditional stocks, but it could be argued that he may have an incentive to do what's best for cryptocurrency world, which could be antithetical to traditional stocks and bonds, and we'll get into a little bit of that later. And finally, he has a lot to do with regulating the field. He has already fired certain players who were very staunch about regulating cryptocurrencies, and said that he was going to be an extremely pro cryptocurrency president. So there's the issue there with, is he going to make decisions that are best for the country, balancing the costs and benefits of cryptocurrency and protecting people against scams, or make decisions based more on what's best for his personal significant financial stake in his cryptocurrency. So most of my argument about cryptocurrency, kind of the further problem of it, is of promoting it, is not just if the president has a personal stake in it, but even if he didn't, I would argue that it would be unethical to promote based on a utilitarian framework, just simply because it does significantly more harm than good. So let's look at this. I'll provide the arguments for all of the harm that cryptocurrency puts on society, and then we'll look at some of the alleged benefits, and you can decide for yourself if you balance the harm against the good there. So first and foremost is the environmental harm. It takes a lot of computing power to mine these Bitcoins and to keep up with the blockchain. It's estimated that we produce 60 million tons of CO2 just from cryptocurrency mining, not just Bitcoin alone, but all cryptocurrency mining, and that's per year, 60 million tons of CO2. Additionally, these cryptocurrency mining farms, they have to stay up with the latest computing processors. If they kept the ones from 3 years ago, they wouldn't be able to keep up. So because of that, they produce a lot of harmful electronic waste as they throw out the old stuff and get the new stuff. It's estimated that they produce 23 million pounds of electronic waste every year. Additionally, as Trump himself noted, cryptocurrencies are known for facilitating illegal transactions, anything from the buying and selling of fentanyl to human trafficking to arms trade, and everything in between. Additionally, it provides an opportunity for criminals through cryptojacking, where you can rob somebody of all their cryptocurrency by using force to force them against their will to give you their wallet passkey, so then you can get all of their cryptocurrency. And yeah, you can do that with dollars too. You can go to somebody's house and put a gun in their face and force them to give you their bank information. But then there's that paper trail of, well, where did you wire the money to? So it just makes it a little bit easier for these illegal transactions. Additionally, yes, you can use the US dollar to purchase illegal arms, but then you have to have, the physical dollars, and it creates a logistical issue. And in some ways they can kind of be tracked. So it just makes things easier, and in a way promotes all of those harmful illegal transactions. Additionally, cryptocurrency scams disproportionately harm disadvantaged communities. And they also divert resources away from more traditional investments and all of the good that comes from more traditional investments. So for example, if you invest $1,000 in cryptocurrency, that's $1,000 you can't simultaneously invest in traditional stocks and bonds. Well, when you invest in traditional stocks and bonds, those companies use that money for a lot of good things. They hire new workers, which is great. These new workers are then going to provide for their families. Their kids are less likely to commit crimes if their parents have jobs. They're going to pay taxes, on and on. They could use that money for research and development to create safer products that we all benefit from. They could use that money to create more environmentally friendly products. They could use that money for creating vaccines and helpful medical treatments that we all benefit from. And also, when you invest in stocks and bonds, indirectly, you have a say in what that company does. You can kind of vote by selling stock or buying stock in different companies based on what those companies are doing, whether it's their DEI policies or environmentally friendly initiatives, or if you don't like that company, using overseas sweatshops or whatever that may be, you can vote, by buying and selling stock and kind of make your opinion known based on that. With cryptocurrency, obviously you can't. So when we look at all of that harm, and there's some other things too, in a utilitarian framework, it basically just says you balance that harm against the good. A lot of things in society impose a harm, but if the good that comes from it outweighs that, it's still a good thing. But here we see many of the alleged benefits of cryptocurrency are vastly exaggerated. So some people point out, well, it provides anonymity. Well, think about somebody in some other country that's under some oppressive regime, and so this benefits them because they can do things without that oppressive regime harming them. Okay, yeah, maybe sometimes that provides a little bit of benefit, but it's going to be minimal because a lot of people in those types of countries probably don't have the kind of internet access they need to be able to do online trading with cryptocurrencies. And those oppressive regimes can just use force to force those people against their will to give up their wallet passkey. So it's probably of minimal benefit there. People talk about, well, diversification. You can add this to your investment portfolio. It helps you diversify, which helps you in retirement. So yes, there is evidence to suggest that somewhat cryptocurrencies are inversely related to traditional investments like stocks, and so therefore they could be used to diversify. But there's other things that are well known to be inversely correlated there that you could choose to help diversify your stock portfolio. So it's really not needed for that purpose. And then finally, some people talk about how it can be used as a currency. I'm hearing this argument less and less. This was kind of bigger 5-6 years ago. There was even, some fast food restaurants had promotions. You could use it. Tesla would accept it. I think more and more of those companies have not been accepting cryptocurrencies for purchases. And even the cryptocurrency proponents are less and less touting its benefit as a currency. It's more of just kind of a investment that you just hold on to. It's not really, if you tried to use it on a large scale for making purchases, it would be a very poor currency. It's very volatile. So, if you have your Bitcoin and you think it's going to go up 10% in the next 3 days, well, you're not going to want to spend it right now. Wait till it goes up 10%. Conversely, if you had some and you thought it was going to go down 10% in the next 3 days, which it frequently does, you'd want to spend it right now. You wouldn't want to wait. You stop work and you go spend it right now, kind of like the problem with hyperinflation. And also the ability of it to make a lot of transactions. These credit cards, they can do 5,000 transactions in a second. Cryptocurrency is way, way slower. So if we tried to scale it up for just everyday purchases, like when you go get gas and things like that, it just wouldn't be feasible in that way. So before I transition to the second topic, in the Q&A, we could perhaps discuss, there's been some interesting discussions as to why Trump changed his mind on this. And I think just in a recent podcast, they had someone from Silicon Valley who was discussing how under the Biden administration, they kind of felt, not with cryptocurrency, but with other issues, especially AI, they kind of felt he was expressing kind of betrayed by the Biden administration, and they were staunchly more on the left. And so then they kind of transitioned over to the right. I think maybe that was beneficial with things like AI. I think it's very important for America to be the leader in something like AI, and maybe cryptocurrency just kind of got included in that bundle. You can probably guess my position on cryptocurrency. Okay, so jumping into our second topic, this might produce a little more controversial questions and comments in the Q&A. So when it comes to the potential of a president to pardon himself, it's a very interesting topic. I'll very briefly give you the 6 arguments for and then the 6 arguments against the ability, the constitutionality of a president to be able to pardon himself. So number 1, the argument 4 would be Supreme Court precedent. The Supreme Court has said that the pardon power is, quote, unlimited, except in cases of impeachment. It extends to every offense known to the law. Congress can neither limit the effect of the presidential pardon nor exclude from its exercise any class of offenders. The pardon limits on the pardon power, if any, must be found in the Constitution itself. Those are all quotes from the Supreme Court. It's established Supreme Court precedent not to review the, quote, character of a pardon. And even going back to Marbury versus Madison, you could look at some of that language there, and it obviously doesn't address even the pardon power, but it applies that these powers to the president are very broad, and the proper recourse for an abuse of those powers is not taking away the power or limiting the power any other way. A second argument, just the plain reading of the text. Even some anti-self-pardon advocates will agree that, okay, yeah, just the plain reading of the text does seem, if you take it literally, does seem to apply that there wouldn't be a limit on self-pardon. And there's the well-established principles of interpretation that if the language is clear, you go by that plain meaning. The plain meaning should be followed. Number 3, the explicit limitations. So there are some explicit limitations on the pardon power that are included in the pardon clause. So that it implies that if further limitations were intended, they would have been listed right along there. And just to clarify, when I mentioned the Supreme Court precedent and the first argument, the Supreme Court, there's very few cases on the pardon power, and there's been no cases on the ability of a president to self-pardon. It actually came up in the oral arguments of U.S. v. Trump. I believe it was Gorsuch, who asked, I forget which side, he asked, well, can a president pardon himself? And the person said, I don't know. It's not really. He said, well, don't you think we need to know in order to decide this case? We kind of need to know that. And they didn't get an answer. So the fourth argument is what we know from the Constitutional Convention debate. At the Constitutional Convention, there were 2 proposals to limit the president's pardon power, not directly limited to a self-pardon. They had to do with other things. But these 2 proposals to limit the pardon power, they were both struck down by wide margins. And one of these proposals really demonstrates the argument here. It would have barred the president from pardoning treason because it would have been, quote, too great a trust. The president may himself be guilty. The traitors may be his own instruments. So in other words, this person was concerned that the president would use the pardon power to get out of himself facing ultimate consequences of criminal actions. So what did they do? Well, the framers debated this proposal, and they concluded that political consequences were the preferred way to deal with such a scenario where the president was issuing pardons to in part save himself. And additionally, at this time, the recent experience and disdain that they had for the authoritarian ruler, the King of England, it would have been foremost on their minds of the framers at the time. Therefore, they would have likely gone out of their way to make clear any intended limitations that they had on the executive's pardon power. The fifth argument is that it would kind of be counterintuitive in nature that upon ascending to the presidency, the president then becomes the only person in the land who can't get a presidential pardon. So if you think of Jimmy Carter's pardoning of the Vietnam draft dodgers, if President Carter himself would have been a draft dodger, which he wasn't, but if he was, it'd be kind of odd that his pardon of all draft dodgers would have pardoned all draft dodgers in America except him. We generally kind of give the president extra protections, not less protections than every other citizen. And then finally, there's some parallels to the gubernatorial pardon power. Alexander Hamilton in Federalist number 69 stated that the power to pardon is, quote, resembling equally the King of Great Britain and the Governor of New York. Although the colonies implemented various restrictions on their respective governor's pardon power, no colony restricted a governor's power to self-pardon, and there is precedent in America of governors pardoning themselves, but in full disclosure, it was only twice, and it was never adjudicated, so we don't know ultimately if that's something the courts would have enforced or not. But there was 2 times the governor pardoned himself, and it was effective. So the 6 arguments against a presidential self-pardon. One is basically a definitional argument that in order to, grant a pardon, that's the language in the pardon clause, to grant something, you can't grant something to yourself. You grant something to somebody else. So it just it doesn't even make sense. It's a non sequitur. Additionally, a pardon is kind of a forgiveness, and you can't forgive yourself. You forgive other people. And I think this is a strong argument. Technically, I think there is an example in property law where if you own 2 pieces of adjoining land, you can technically grant an easement from one piece of land to the other. So you'd be kind of granting yourself something. And I don't know much about the area of psychology, but based on what I know from watching sitcoms, they're always asking people to forgive themselves. So not sure how strong of an argument it is, just kind of based on the definition of you can't really forgive yourself and you can't grant yourself something. Another common argument that comes up against the self-pardon is that it's just not allowed under themes of the Constitution, such as self-judging. You can't be a judge in your own case. And that's certainly true. You can't literally be a judge in your own case. You can't sit, in the judiciary as a judge in your own case. But a self-pardon is not really like being a judge. It's totally separate from the judicial process. It doesn't, a pardon doesn't say that somebody wasn't actually guilty or that the judge's determination wasn't real or anything like that. It's just totally separate from that. It's an act of forgiveness. And this is illustrated if you think of a true judge would be forced to recuse himself in a case where his son was being prosecuted, obviously. But a president is free to pardon his own son, as we just saw. That's perfectly allowed. So that demonstrates the difference between utilizing the pardon power from the executive and a judge. So it's technically not really self-judging. It involves a judgment in the sense of a determination. You have to determine to issue the self-pardon, but it's really not a judgment in the sense of what judges do. Additionally, some people say, well, it's self-dealing, it's self-serving, and it very much probably would be a self-pardon, but there's no constitutional limit that you can never do anything that's self-dealing. Some pardons in the past, H.W. Bush pardon of Iran-Contra prosecutors. There's other examples of presidents that use the self-pardon in ways that are pretty obviously self-dealing. It would be absurd to expect the Supreme Court to view everything a president does and somehow strike down everything that they determine to be in some way self-dealing. Some final ones, some say, oh, well, it makes the president above the law. No man is above the law. Well, he would be no more above the law than anybody else who receives a pardon is above the law, and any more so than anybody else is above the law who avoids the consequences of their criminal actions, such as through the exclusionary rule or a statute of limitation or prosecutorial discretion or anything else that's built into the law. Next, there's the Nixon memo. This was a memo written by Nixon's assistant attorney general, essentially just asserting that a president cannot pardon himself. No real kind of reason was given. It was just a single paragraph, the part that mentioned the pardon. I would argue that that would be no more effective than Trump's assistant attorney general asserting that you can pardon yourself. And then finally, some people point to history and tradition. We've had a lot of presidents. Some of them have had an incentive to pardon themselves, and none of them have really gotten close to doing it. So that kind of demonstrates this history and tradition that you can't do it. Okay, but up until a few months ago, no president had ever pardoned his son, but that doesn't mean you can't do that. I think that pardon was perfectly valid. Okay, so I got a lot. I'm picturing. I can only see one person in my screen here, but I'm picturing people in the audience just rearing to go. They've got something. A very passionate response, whether to the cryptocurrency part or the self-pardon part. So hopefully I've given you enough fuel there to kind of stoke the fire. So I'm very curious to see what questions and comments we have here.
Professor Conklin, thank you very much. Am I the person in your screen?
Yes.
I am, okay. I was just curious. There is a room full of students here, but let me begin with a question about cryptocurrency. And I want to draw some comparisons with another very, very traditional form of currency that has been around for thousands of years, gold. Gold is not like stocks or bonds. There are no social benefits accruing to the ownership of gold. You simply own gold. Gold is difficult to mine. You have to go down thousands of feet. It poses all sorts of environmental and health hazards. Physical transfer, given the dollar value of gold, it is easier to transfer a gold ingot than 10 suitcases of cash, and they'd be about the same equivalent value, I would guess. The transfer of gold, like the transfer of Bitcoin, is anonymous, perhaps even more anonymous than Bitcoin. And it is hard to make a standard purchase with gold. I can't walk into the Tesla dealership and drop down a gold ingot and expect to drive away with a car. So gold is our oldest form of currency. Cryptocurrency is our newest form of currency. If we allow one, if gold is this long acceptable medium of exchange, why not crypto?
Oh, I think that's a great question. And I've never thought of the comparison to gold. So I think, yes, gold has been the standard or was the standard for so long because there was no better option out there. 600 years ago, currencies from countries were probably much less trustworthy and stable than the US dollar is today. So gold would have been a more attractive option. But I'm not sure gold, I think it'd be more difficult to steal than cryptojacking people and to stealing their money. And its use in illegal transactions, I'm not aware of the science behind how you test gold, so I don't know how easy it would be to test gold if somebody showed up to hand over $2 million worth of gold to get a bunch of fentanyl. I'm not sure how easy that would be to do. I mean, I guess we could just look, 10 years ago or 15 years ago, before so many people were using cryptocurrencies for illegal transactions. I wonder how many of them were using gold. I'm not aware of this. Based on the court cases of, confiscating money from drug dealers, I can't think. It's usually cash and not gold. So I'm not sure gold is such a great facilitator of those illegal transactions. I think the environmental part is very similar. Yeah, I think there's a lot of environmental harm to mining gold, and I assume just like with cryptocurrencies, the more and more you mine, you take the low-hanging fruit first. It probably gets even worse and worse for the environment as we go on to get the harder to find gold. So I think that is a very interesting analogy. So I'd have to think about that. So yeah, somebody who invests heavily in gold, I've never thought of that of being an unethical investment. I have to think about that some more. I mean, by driving up the price, you are incentivizing more and more of the mining, the physical mining for gold. I think that's an interesting comparison. Yeah, I mean, gold does have an intrinsic use too. I mean, as like electronics, like as a conductor or something. I don't know the science behind it, but it does have, very legitimate uses, which I would argue cryptocurrency absolutely does not. But yeah, it's an excellent point. But instead of me saying, well, you're right, I guess crypto should be used like gold, I guess I might be more inclined to go the other way and say, oh, I'll think about it some more, and maybe I would agree that investing in gold is additionally unethical. Yeah, but excellent point. Yeah.
Thank you. We have students here who have questions.
Hi, my name is Claire Beinhorn. I just want to thank you for your excellent presentation. I have a question about crypto as well. I think one can make an argument that there are some core benefits to crypto as a decentralized currency. I mean, foundationally, coming from the 2008 financial crisis, from the failures of our government and financial institutions. I guess I was wondering what you think the future of crypto should be and how the government should build a regulatory framework around it.
I think there's there's obviously some benefit to crypto. So I definitely wouldn't, I think maybe I did earlier say there's no benefit. So there are some, but I think the downsides vastly outweigh the potential benefits. And I think additionally, there's benefits to be had from using the blockchain for other purposes. As far as crypto, yeah, I mean, we've had these crises in America before. I don't see how more crypto would have prevented them. We may be this year headed towards another one of these financial crises, and yet we've got a lot of crypto, a lot of valuable crypto. So I'm not sure how that's going to protect us from another financial crisis. Yeah, I mean, in countries that have hyperinflation, I guess you could make that argument that even though cryptocurrency is extremely volatile, if you had very good reason to believe that your government's currency was just going to plummet, 800% in 1 year, it could be a safe asset to hold. Of course, you could just hold US dollars instead. Yeah, I just don't see it as a very viable protection against a financial crisis. Yeah, I mean, the financial crisis that you just mentioned, I mean, I would argue it wasn't the product of our government's, like that from the housing crisis. It wasn't really a product of our government, inflating our currency or a policy like that. So, yeah, I'm not sure how well widespread use of cryptocurrency would have protected us from that crisis or a potential impending financial crisis in 2025.
Hello, my name's Denisa, and thank you so much for joining us here today. My question is in regard to the second portion of your presentation. We know that before President Biden left office, he not only pardoned his son, as you mentioned, but also other family members and Dr. Fauci, who haven't even been indicted, charged, or convicted of a crime as of yet. And so my question to you is, what is the constitutionality of those pardons, and how far-reaching is it?
Yeah, excellent question. So those are preemptive pardons, and it's very well established that that's allowed. There was a case somewhere in the 1800s that argued that. So to clarify, everybody gets confused about this. A preemptive pardon means that you can pardon somebody for something they may have done in the past, but have not yet been punished or prosecuted, or even nobody else is aware that they did. You cannot, hardly anybody thinks you can pardon somebody for something they haven't done yet. So Biden couldn't pardon his son for things he might do in the year 2030. You can't do that. But you can pardon somebody, and this is often the case. It just depends on how you word it. I think Hunter's pardon was Biden's son's pardon was something like for all offenses from this date to this date. I think some other pardons are worded that way too. Nixon's pardon was for all crimes against the federal government from this date to this date. So if it later came out that President Nixon murdered somebody in Washington, D.C., it would have to be, it couldn't be a state, because then the state could prosecute him, and the federal pardon wouldn't do anything for that. So yeah, if it later came out that Nixon literally murdered somebody in Washington, D.C. during that time period, that'd be covered by that pardon. He'd get off not scot-free because there'd be political consequences and reputational consequences, and he could suffer civil. The surviving family members could sue him in civil court for wrongful death. But the federal criminal consequences, he would get off scot-free. Yeah, so that's a preemptive pardon, and I agree with that because otherwise, I mean, why should somebody get to receive a pardon or not get to receive a pardon just because they happen to be prosecuted on a given day? Just because the federal government waited to start a prosecution, now you can't get your pardon. That kind of seems unfair. So yeah, and a president should be able to exercise their pardon power if they see fit to stop an investigation. Say, hey, we want to pardon these maybe group of people because I know you're about ready to start an investigation, and as the executive, as the president, for whatever reason, I just don't feel like that's a good use of our resources. So I'm issuing this preemptive pardon, and therefore no prosecutions for those people in the future for things that they've already done up until that point.
Thank you so much for that answer. My second question is, I'm not sure if you know the answer to it, but we also know that Trump was able to run and also secure presidency as a convicted felon, and individuals can't even vote as felons. And so I want to know I'm still trying to figure this question out, but like what your thoughts are on that. And is there something in the Constitution that allows for what Trump was able to do? I'm assuming yes, because he is a president. And if so, is there any safe havens or anything that we can do to kind of use that argument in support of allowing those who can no longer vote to vote? Sorry.
Yeah, so it's my understanding that I know that Florida used to have felon disenfranchisement, which means, if you were a convicted felon in Florida, you couldn't vote. I think they did away with that. I think they were one of the last states. So I think in America, the majority of former felons can vote. There may be a couple states who don't allow it. I think there's even one state that allows people in jail, felons in jail. I think there's a few states actually that allow you while you're serving your sentence to vote. So assuming there's a couple states left that don't allow former felons to vote, that's if he happened to be a registered voter in that state, he wouldn't be able to vote. But who is able to become president is in the Constitution, and it doesn't say anything. They have to be, they have to be 35. They have to be 14 years. They have to be a citizen of 14 years. There's a couple other they have to be a natural born citizen. I think a citizen of at least 14 years. That might be it. I'm not sure. So there's no requirement that you cannot be a convicted felon. And I'm in favor of that, regardless of what I think about, who should have won the last election. I'm in favor of that. If in a representative democracy, you get the government that you deserve. And if that's who people want to vote for, then that's what you get. I think people should be free to choose that person, even if they have a felony in their past. So I think there's a reason in the Constitution it's very open-ended. Just if that's what the people want, that's what they get. So if you wanted to change that, you'd have to amend the Constitution to say, convicted felons are not able to run for president, not able to sit for president. That'd be very difficult to do, but you'd have to do that because otherwise the requirements are pretty clear, and there's no requirement that you can't be a convicted felon. Or as some people may put it, I remember there was one, I don't know if it was San Francisco, there was one place that was trying to pass some amendment, or some, I don't know if that'd be legislation technically, but something to where instead of referring to people as felons, they'd be referred to as justice-involved individuals. So maybe we should, Trump is a justice-involved individual. I always thought that was very, very clever. It's like, well, how were you involved in the justice? Were you a bailiff? Were you a judge? Oh, you were the guy who got convicted. Okay, well, that's putting it very nicely. A justice-involved individual.
Hi, my name is Jenna, and I was just kind of curious how you would see this, if Trump does go ahead and pardon himself, how this would play out politically, ethically, like what kind of things we might see, conversations that might be having, since this is kind of in the early ages talking about this. I'm kind of just curious what we might see change, what might happen, I guess, in your perspective.
Yeah. Oh gosh. Yeah, it would be a huge mess. I hope he doesn't try to do it, even though, as you can guess from my presentation, honestly, I believe that, based on the plain reading of the constitutional text, I think there is a right of a president to issue a self-pardon. Yeah, that said, I really hope he doesn't. I think it would be it would just create a huge mess. What more can I say? Yeah, so, if he issued himself a pardon, and then it wouldn't probably be until after he left office, if then he was criminally prosecuted for the thing that he allegedly pardoned himself for. Yeah, he would try to appeal on that ground, say you can't prosecute me for this. I have a pardon. Yeah, honestly, I don't even know how that would go up. There'd be this issue of, what would the makeup of the Supreme Court justice of the Supreme Court be? Especially if he gets to appoint one or more people in the interim. It would be a constitutional maybe crisis is a little harsh, but it's something that I hope we don't see. And a lot of his issues wouldn't even be suitable for a pardon. If he could be prosecuted at the state level from some other state, then the pardon wouldn't do anything, because the president can only pardon somebody for federal offenses against the federal United States. And then, of course, if individuals were hurt, again, they could sue in civil court. So he would still potentially have those liabilities. And then also there's, like I said, the political consequences of if he was concerned with a reputation or something like that. That's I'll leave it there.
Hi, my name is Brad. Thank you for your presentation today. My question is kind of focused on some of the political solutions, I guess you will, that you've talked about. Of course, we have impeachment or facing re-election, but perhaps when the founders were considering this, I know you made a comparison to like King George of England. Do you think that they thought that was a sufficient, remedy to, I guess, obviously some level of immunity is required for the executive branch to, be co-equal to the judiciary. But do you think that impeachment, I guess, is enough to prevent some sort of, executive tyranny of some sort?
Yeah, so it depends. And I would argue that even though there could be a potential scenario, like his last day out of office, where impeachment wouldn't really be on the table, just because there's those potential scenarios, that doesn't mean that therefore the framers intended it never to happen, and you can't do it. You have to balance these things, right? There's trade-offs involved. There's no like perfect solution. It's just trading off. Do you want more of this and less of that? So I think the framers, I'm definitely not 100% sure what the framers would have thought about self-pardons. There's no specific, they didn't address it specifically. So of course, anti-self-pardon people can point to that and say, yeah, they didn't address it specifically because it's so obvious. It's just so ridiculous. It was just assumed, they would say, it was just assumed you can't self-pardon. It doesn't even make sense to self-pardon yourself. So it's, just nonsense. They had limited time. They didn't want to address like every idiotic thing that somebody like me could bring up. They would argue. But I think it's more clear, just they were always in favor of, on the pardon issue, more power to the president, and not we could limit it this way. No, there's political consequences. This person was elected. No, we give him that broad power. We don't want to start limiting it. It's a check against the criminal prosecutions. So I believe if we went back in time and went and interviewed them, I'm not 100% sure, but I think they would say, yeah, that's part of the power. And yeah, a president could come along and could abuse that, but that's part of the system. A murderer could come along and get to go free because of the exclusionary clause. or the excluded evidence, the exclusionary rule. That doesn't mean, oh, well, just because a potential bad occurrence could happen, we got to do away with the exclusionary rule. No, you balance that. It's, you know, the exclusionary rule has some negative consequences and has some positive. You balance them out. So yeah, just because a potential president like Trump on his very last day could issue himself a self-pardon, and then the checks and balances of worrying about your reputation and being impeached wouldn't be present. That in itself doesn't automatically mean that it's not allowed, just because there could potentially be a bad outcome. But yeah, that's a great point to think about. Yeah, there are instances where those natural checks wouldn't really be present.
Well, we have no further questions, so thank you so much, Professor Coughlin, for your time today and your very insightful keynote, and we will head into our third panel of the afternoon.
All right, thank you so much.
All right, in our third panel today, we'll explore the legal, economic, and security consequences of a second Trump administration's policy shifts, with a focus on immigration, trade, financial regulation, and global diplomacy. Panelists will analyze how stricter immigration and trade policies could impact rural economies, particularly in agriculture and labor markets. The discussion will also examine the broader impacts of financial regulation, including ESG investment policy, Social Security, and retirement benefits, which will affect millions of workers. Additionally, the panel will assess U.S. foreign policy in Eastern Europe, considering potential changes to the NATO commitments, transatlantic trade agreements, and diplomatic relations with Russia. The panel will begin with Andrei Dumitriu Altanu. Andrei Dumitriu Altanu is a PhD student in his third year at the Faculty of History and Philosophy of Babish Bolyai University, doctoral school, history, civilization, and culture. He also teaches seminars on analysis of Romania's foreign policy and introduction to contemporary history of Romania. At the same time, Dumitriu is a research analyst at Goldman Sachs. Dumitriu is an American Council for International Education 50 of 50 alumni and an LSE Ideas Award winner for essays in history. He has participated in over 25 conferences and published articles and chapters in collective works on the Cold War, communism, cultural diplomacy, and propaganda. Next, you will hear from Alex Schaefer. Dr. Alex Schaefer is an associate professor of international markets, trade, and policy in the Department of Agricultural Economics at Oklahoma State University. He holds a Doctor of Philosophy in Agricultural and Resource Economics from the University of California, Davis, and a Juris Doctor from the University of Kansas School of Law, where he specialized in international trade and finance. Dr. Schaefer's interdisciplinary expertise spans economics of law and law, focusing on trade policy, agricultural markets, and rural development. Dr. Schaefer has published extensively on issues related to agricultural trade, policy impacts on rural economies, and the intersection of global markets and domestic agricultural systems. His work has informed policymakers, industry stakeholders, and academic audiences contributing to discussions on sustainable development, food systems, and economic resilience in rural areas. He has also served as a legal and economic consultant on high-profile cases involving multinational corporations in the agricultural sector. Lastly but not least, Lauren Velastro. Lauren Velastro is currently a visiting clinical associate professor and the director of the Entrepreneurial Law Clinic at the University of Colorado Boulder. She will join her alma mater, Texas Tech University School of Law, this coming fall as an associate professor, where she will teach business entities and contracts. Professor Velastro received her BA from Texas Tech University, where she graduated first in her college class. After receiving the Chancellor's Scholarship for a full law tuition, she earned her JD from Texas Tech University School of Law, where she was a comment editor on the Law Review and a clerk for the Honorable Reuben Reyes. After law school, Professor Velastro engaged in an extensive career as a litigator, where she secured first chair, trial, and appellate victories, argued before the United States Court of Appeals for the Second Circuit, partnered with sovereign tribal nations on environmental issues of first impression, and became the youngest partner at a national boutique law firm. Later, she transitioned into in-house counsel for a private equity firm where she advised executives on strategic risk management and negotiated multi-million-dollar transactions, contributing to the firm's rapid growth. Professor Velastro's scholarly inquiry lies at the intersection of procedure, U.S. retirement policy, and the resulting tensions inherent in a system serving a diverse constituency with varied needs and retirement objectives. Please join me in welcoming our first speaker, Ande Dumitru Altanu, to begin.
Good evening, everyone. I see two persons in the room, but I think after all of the applause, I think there are a lot of people. So thank you. I think there are 7 hours between us, and I will. In just a couple of seconds, I will share my screen. So today I will talk about shifting boundaries during Trump's second term, Trump's foreign policy and Eastern Europe transatlantic future. And thank you for your presentation. It was very kind, and thank you for your applause. So I start by thinking on the last 3 months into President Donald Trump's second term. And I think that Eastern Europe is once again at the center of transatlantic uncertainty. The administration has reaffirmed key foreign policy traits, skepticism towards NATO, transactional policy, diplomacy, and preference for bilateral over collective agreements. Trump's comments suggesting limits U.S. protection for underspending NATO allies have unsettled European capitals and prompted strategic recalibration. This is particularly visible in Poland, which continues to strengthen its U.S. defense ties, while countries like Romania are trying to balance transatlantic commitments with EU alignment. The credibility of U.S. security guarantees is now in question, just as regional threats' intensity. KUS figures are also shaping this moment. Senator and Marco Rubio last year reflected the strategic direction of Congress, while Vice President Vance inherits a legacy of high-level regional engagement. Whether he will maintain this tradition set by Biden and Pence to visit Eastern Europe remain a vital question for Eastern Europe. As we assess these developments, it is fitting to remember the words of the person who give the name of your university. And when I received your acceptance, I immediately, and when I saw the call for papers, I immediately thought at a quote from Tomás d'Aquino, who received, and the quote is, "You receive the divine light in vain if you cannot share it with others." And this lecture aims to shed light on how Trump's second term is reshaping global diplomacy and what is the means of Eastern Europe's future. In the face of disruption, how should Romania and its neighbors respond? And this is one of the questions that I will try to respond. And while they double down on transatlantic integration or pursue new strategic equilibrium. Yes. So the base question that I will have to respond, and I try to respond in these months, are how has Trump's approach to diplomacy, regional strategy, and digital influence reshaped Eastern Europe foreign policy, and what does Trump's second term means for Romania, Poland, and Hungary? As a methodological approach, I will have in mind three points. Qualitative comparative case study focusing on Poland, Hungary, and Romania. Of course, primary sources who are very vital. And for this, I looked at a period from 2012 until now to see public speeches, Congress speeches from different person around President Trump and also from President Trump. And I tried during this time to find a pattern because as a young historian, always as micro and micro historians do, we try to identify a pattern that will respond to maybe some how should we say maybe a response for the future's developments regarding the diplomacy and how the President Trump will try to manage his policy regarding different countries or maybe blocs. And also publication from think tanks, which will be very helpful, which they are already very helpful. And it was really an interesting and a very good exercise because you need firstly to create a context like every time, but historians always do and try to look more on the context and then to try to answer and to give some answers regarding what will come next. As you know, there are different time and very hard thing to do to make some suggestion on that. But in the last minutes of my presentation, I will discuss about 3 scenarios. So regarding the context and continuity, we will see, and as I saw, the first administration of President Trump was more bilateral over multilateralism, and his approach regarding European Union was more on how to deal with every country from European Union and not as a whole block of community. And also the scholars introduced during Biden administration this term who become more and more important during this day, and that is transactional diplomacy, which I think in the next 4 years will become more and more important to understand and to see what because I think this is the first and foremost important thing to see right now. And the ambiguity toward NATO and Russia. We see, and in all of the meetings from NATO in Brussels, we see and we saw different approach from other presidents. This was clear, and the continuity in the second term will reinforce skepticism toward NATO because there are a lot of questions regarding how US will be more present to Europe, and what are the main points that the Trump administration will try to catch and to understand to become more and more engaged or disengaged in this, because as we see in these 3 months, US is finding a new approach, and they are looking more on the Pacific and not in the transatlantic part. And we also need to understand the new bilateralism and how every country in these 3 months try to figure it out and to understand and to speak not as a community, because it was also very difficult during these three months. As I saw, a lot of countries from European Union try to not engage with the as a bloc of community with Trump administration, but as bilateralism. But after I think in the last few weeks, I saw a very good aggregation of European Union and try to communicate with Trump administration as a European Union and not as an individual country. We see, and I will make a zoom right here, sorry. Eastern Europe now as a crossroad because, as you saw, Russian persistence, regional influence Ukraine, more what was happening in Crimea, the energy problem with in relation with Germany and with northern countries from Europe, and the information war was very different, as you know, and the implication in some of the elections, also in Romania and the other countries, was very intense. And the US as security guarantee versus US as normative actor, tension between sovereignty and integration are more and more present on my research, and I will also try to explain more after. Another thing that is very important now, it's to look at individual, the main key figures that will shape these relations. We need to understand and to see every speech of President Trump and to understand if there is a way on how the administration and the European Union, from Brussels to Strasbourg and to any other key figure sector that want to communicate with the Washington administration, will try to enable and to beside the skepticism regarding how they see democracy, how they see maybe their relation with Biden administration, because as what happened in, and I will go now at the vice president, what's happened in Munich was very intense, and a lot of leaders from European Union raise question regarding the transatlantic relation, but it is very important every time there is a discuss between when questions are raised regarding transatlantic relation, to look at the Secretary of State, Marco Rubio, because every time there is a problem between transatlantic relation, diplomacy will always find a way to solve things. And one of the key figure that is deeply understandable with his position, it's Marco Rubio, who is very present during this day and really try to translate in other terms, more diplomatic terms, how Washington administration understand this relation. Regarding Poland, there is a very nice understand by the Washington regarding the high defense spending. Poland is one of the NATO member states who spend. I'm not sure, but I think they are spending they with and then Baltic states more regarding the GDP for defense spending, and they advocate again and again at every meetings, not just state NATO, but also bilateral meetings, on to reinforce and make a very strong eastern flank, because as we saw, it's very intrusive and very difficult to understand with each other country when the defense are not spending. And this is why of the things that is very important, because the speech right now of the Trump administration wake up the countries from Europe and explain them again that is very important to not put aside their spending on military, and also to protect themselves and not just let the US to do all the things. So this was very important, and one of the things that come together right now in the European Union is to rethink about maybe European Union army. So again, France try to re-engage with this, but regarding Poland right now, there are strong bilateral military ties, because as I know, as you know, President Duda from Poland have a strong relation with Donald Trump from the last term, and as you know, Hungary have strategic autonomy, but This didn't help so much regarding tariffs because, as you know, Trump administration imposed tariff on whole European Union, so Hungary wasn't accepted from these tariffs. So the relation between Viktor Orban and Trump wasn't so helpful for Hungary. And right now, Hungary is, I thought, and I hope they will do, but from what I search right now and from what Viktor Orban speak in the public is that he tried not to engage with, to give a response for Russia and for United States with all the European bloc, but to be on their own regarding diplomacy and relation with US. And of course, there are friction between European Union, and that is why Hungary, over the rule of law, the European Union and the Commission imposed a lot of sanctions regarding this and regarding the free speech. But there are things that are no, because there are no more publication that are that have autonomy in the Hungary. But let's not discuss and develop more right now in Hungary, because as I thought, when we are talking about transatlantic relations, we need to get together all of the states from the European Union. Regarding Romania, Washington administration have three very important points, and one was the anti-corruption strategy of the country. In every meeting, every bilateral meeting, the last president that we had, now we have elections, again, elections from presidency, but Klaus Iohannis, the last president, had two meetings at Washington, more meeting when President Trump come in Brussels at NATO meetings, and they had always three main points that they discussed. One was the anti-corruption strategy and how this should solve, and also the U.S. defense spending and digital partnership, because the digital partnership was also implemented in the discussion with Poland, because these two countries have in Eastern European flank one of the most important companies that are also that have headquarters in United States, and they are doing a lot of businesses in US, in Romania and Poland, and also defense spending. Romania almost 80% of the military equipment are bought from the United States, from F-35 to military equipment, a lot of and also investment from billions of dollars that are made by the United States in Romania. And also another point that was discussed, and now it's raising a question regarding U.S. implication in Romania. It's the Kogalniceanu based military base that Romania and U.S. are investing right now. And in 2-3 years, is discussing that this military base, will become the hugest military base in Europe. Right now, we should see what's happening if the U.S. will stay again and will engage in this development, because as I will thought and I wrote it here, approximately 2,050 troops are in Romania, about 2,050, and in some days, last days, I think from Pentagon, because as we know, history is written every day. there were a hint about maybe a reduction of U.S. troop presence in the Eastern European Union and more in the Poland and Romania. And this raised some question regarding the development of the Kogalnichano base, as I told you. This will be interesting because if the US will reduce his presence in the Eastern European, now we should see that in maybe next 2-3 years what will happen with the defense shield that is in Romania, and also what will happen with the US troops in Poland. So these are some of the questions that are raised. Also, another thing that is very important is the 3C initiative that was launched in 2015, aimed at the regional infrastructure integration. So the 3C initiative, we need to see Biden administration participated in some meetings of this initiative. Some meetings what was happening in Bucharest, some in Warsaw, and the idea is that to connect with infrastructure, with train and with highways, Poland and Romania, and to have a very integrated flank. But now there are some potential revival because the Belt and Road Initiative that is implicated from and come from Chinese and from China, we should see right now a new presence of this, because there also, if this initiative will find his way and they will finalize the most important project, and one of this is the main highway that will be realized between Warsaw and Bucharest. If this will happen, this will put in charge some of problems for the Chinese for the China economy. And regarding legal norms and flexible games, why I'm talking about bilateral challenges and international legal frameworks is that there are no more reliable things and thought on how European Union and United States we understand each other when they have to make the same position on some issues regarding maybe China, maybe as you know, as we see right now, Russia and Ukraine. And when I'm talking about short-term economic security benefits and long-term institutional trust, we see that in terms of negotiation, when we are looking right now in Ukraine, there will be a different approach on how European Union and the US see these issues, because European Union will want to continue and to not let Ukraine lose some the territories that are now Russian troops on them. So there will be interesting to see how international law will be implemented in terms of negotiation, and what will be the parts that will be participate in the negotiation. I think I have to get ready. So get fast with scenarios for Trump's second term. I think that the first scenario will be to reinforce bilateral deals, weaken NATO cohesion. The second scenario is to strategic autonomy gains transaction in EU, and the C is digital decoupling between US and EU. So as we know, a lot of businesses that are dealing with, and the big tech companies that have also headquarters in European Union are now facing some challenges. And if as you know, tariffs wasn't postponed for 90 days, the European Union Commission, Ursula von der Leyen, probably will put some tariffs on and some taxes on these tech companies. And this interdependence between US and EU made them stronger, but if they are decoupling regarding the digital and tech evolution, I think the competition between them will not evolve in a way that both parts will gain some good implementation regarding their developments. So as I saw and as I realize right now and conclude on with my I say pattern. I think that in terms of digital relation between United States and European Union will not be effective because the evolution right now with AI and how companies in the US collaborate with companies from European Union, develop and succeed on reaching at this point at this level. But the competition between them, if the taxation and everything will come up, they will be not successful from both sides. In conclusion, Trump's second term presents renewed dilemmas for Eastern Europe, and we will see in a couple of weeks, I think, what will happen with troops. This will be more important, but this is one of the things that is interesting because European Union will invest in, I think, $800 billion for countries to invest in strategic, but this will be different right now because the countries that are receiving this money will not be allowed to buy military equipment from United States, but from companies from European Union. So this will not be very helpful from United States companies that are doing business on military because, as you know, Poland, Hungary, Slovakia, Czechia, Czech Republic are buying a lot of equipment from US. So this will be very interesting to see regarding bilateral and multilateral understandings. And another thing that I want to talk about was strategic agility in K for Romania, Poland, and Hungary, and transatlantic trust must be rebuilt or reimagined. The question that I will let you in this night for me and this evening for you will be, can Eastern Europe remain secure and globally relevant without strong multilateral backing from the US? And my answer is yes, because this will not be a fast way to retreat. US certainly, as I see, will help Eastern European countries to create a strong military, and this is after Marshall Plan, after 1945, after the fall of the Soviet Union, the fall of the Eastern Bloc. This will be helpful to become a more strong country to deal on their own with Russia. Thank you for your time.
Thank you, Ms. Deltanu, for that very thought-provoking discussion today, and thank you for your time. We know there's a big time difference between us and you, so thank you for being with us today. Next, we will go to our second panelist, Dr. Alex Schaefer.
Okay, so thank y'all so much for inviting me. This is a really cool event in that I believe, I can't see y'all, but I imagine most of y'all are lawyers, young lawyers, preparing to be lawyers. In the last presentation, y'all got to pretend like you were kind of Eastern European political historians, political philosophers. For this presentation, you get to step away from being a lawyer for a little bit as well, and you get to pretend like you're an economist, right? And so the big kind of motivation here is, okay, if you've watched the news, we've got all this big stuff going on. We've got these massive reciprocal tariffs. Maybe we don't have these massive reciprocal tariffs. What does this all mean for me, right? Where in my setting, the me is kind of rural America, right? I'm a kid from rural America. That's sort of my petri dish and a lot of my research, and it's sort of my motivation for how do we understand the world around us. So I teamed up for this thing with one of my friends at the University of Vermont. I'm kind of focused on the big picture trade policy dynamics, and he's focused on kind of the community development aspects of this stuff. Oh gosh, it's not letting me share or switch. There we go. Okay, so then let's start out with a story to kind of motivate this thing. In that when we think about rural America, we know that kind of over, I don't know, the last few decades, when we compare rural America to urban America, we know that rural counties of the U.S. have experienced less economic growth. We know that rural counties of the U.S. are poorer on average. We have higher earnings in urban areas than we have in rural areas. We know that when we think about where the workers are, kind of the prime age workers, they tend to be in those urban areas. The rural ages are a lot older these days than urban areas. And we tend to think of rural economies as much less diversified, so kind of focused on one primary industry as a driver of that economy as compared to urban areas, which might have a whole bunch of different kind of sectors in that area. And so that's sort of the setting. I want to take you to a place where I grew up, which is Texas County, Oklahoma. And kind of during the time I grew up, we were thinking of it in that way, right? That it was sort of a place with low earnings, high kind of unemployment, and sort of stagnated growth. And then as soon as I leave, things kind of turn around, right? So if you look at this top graph, let's see. I'm not sure which screen y'all are seeing, but if you look at this top graph right here, we see kind of a decade ago, oh my gosh, things start growing up. This is our real GDP in 2017 dollars. So in about 2010, everything started really picking up. One of the reasons for that turnaround and sort of the economic growth in Texas County was a packing plant. We have a seaboard pork processing plant, and kind of as a driver of that, the demographic face of a person from Texas County, Oklahoma looks different than it did 20 years ago, right? So this down here is our demographic population, where the green line is the Hispanic population. So these are either new immigrants from Mexico, Central America, or sort of first generation Americans who are the descendants of those immigrants. Whereas the kind of the non-Hispanic population has declined, but on net, we're sort of growing. If you look at the voting patterns in Texas County, overwhelmingly Texas County supported Trump in the 2024 election. And that's kind of true across the board in rural America, supported Trump in this election. But at the same time, these same communities, for the reasons that I discussed at the start of this things, are those that tend to be most exposed to those trade and immigration challenges that sort of are on his policy agenda. So here's that electoral map that probably everybody has seen, where if you're familiar with what the U.S. looks like in terms of rural and urban, pretty much everywhere on here that's red, with just a couple exceptions, are the rural areas, right? And then the kind of blue areas are the ones that are more urban areas. By the way, I said I'm from Oklahoma, and we are actually the only state in the U.S. that every single county voted for Trump. Let's see. Okay, so where are we at? Here's sort of the overview of the trade policy stuff. I know you guys have had lawyers who are probably much more up to date and more nuanced in sort of the legal implications, the legal procedural details here. So I'll kind of skip over this a little bit, but just say, yeah, this is different than the first Trump administration, right? We had a trade war in the first Trump administration, which was sort of these targeted tariffs on targeted industries in targeted countries. This is a big deal now, right? We have first these 10% tariffs on all imports from everywhere. Until yesterday, we had this discussion of these reciprocal tariffs with different countries. Looks like those have been taken away with the exception of China. We've got some specific industries being targeted with additional protections as well under Section 232, the lumber, timber industries, the pharmaceutical industry. And these things are now tied to broader issues like fentanyl migration than they were in that 2020 or the first Trump administration, right? And so these things create real risks, real vulnerabilities to our supply chains from a national perspective, right? Oh yeah, so the point on the right here, this global economic policy uncertainty index. Like I said, we were facing these reciprocal tariffs until yesterday. Turns out maybe we're not going to face those, or at least he kind of kicked them down the road by 90 days. The uncertainty itself is really, really important in terms of forming these supply agreements with our international buyers or our suppliers. If we don't know what the rules are going to be tomorrow or maybe even today, there are costs associated with that. Even if these tariffs never go into place, right? So this global economic policy uncertainty index is just a way to measure how sure am I about what the rules are in the world right now. If you look at this thing over time, here's the Great Recession. We had a lot of global economic uncertainty. Here's that first trade war, which was more uncertainty even than the Great Recession. COVID-19, more uncertainty still. And then January 2025, so a couple months ago, this was before even the tariff will they or won't they's of February and March. We were at the highest point of uncertainty sort of since the WTO was created, right? So there are real risks associated with these trade policies. Same kind of concept on the immigration story here. 10 executive orders signed on day one dealing with immigration. Most of these were putting back in place the policies from the original Trump administration, kind of undoing the changes that Biden made. But we've also got some additional kind of mandates that if I'm a migrant, I'm registering. We've got this option to say I'm self-deporting on an act. We've got on an app, we've got the Lake and Riley Act, which says we've got mandatory detainment for any undocumented people who commit kind of shoplifting crimes, burglary crimes, etc. And it looks like there's more legislation that's potentially on the way. And we're also seeing increased actions on this. We've seen sort of a rise in these detentions and deportations. And as a result of that, we've seen a dairy farm in South Dakota and some of the fruit harvesters in California already saying, hey, look, we've got more shortages of workers than we anticipated already. Okay, so these policies are already starting to bind, have an impact on the world. What does the rural economy look like? And so how might this affect our rural economy? Well, when we think about the rural economy, I've got a slide coming in a bit here that shows that it's primarily goods-focused industries, extractive industries, and for these extractive industries, about 20% or $1 in every $5 relates to exports, is reliant on exports. but it's actually even more important than that, right? Because it doesn't matter if the commodity or the good that I'm producing actually crosses a border or not for it to be affected by international trade, right? So if I am in a kind of a global market and there are changes in import-export dynamics in such a way that it affects my domestic prices, because I kind of have this integrated market, I am going to be experiencing those price effects on my product, even if it never is involved in that kind of international trade system. When we think about agriculture, maybe many of you know this, 70% of the farm workers we have in the US are immigrants, and approximately half, 50% of the farm workers we have in the US, I believe it's 50%, are undocumented workers, right? So the immigration really matters here. Let's see. And given that the rural economy is less diversified than urban economies, we are really vulnerable to these shocks. Let's see. Okay, so here's some maps to talk about sort of the goods producing, so those extractive industries plus manufacturing industries that I talked about. For a lot of reasons, goods are more sensitive to international trade or more exposed to international trade than services, where we think of primarily urban economies are more represented in the services sector relative to rural economies, which tend to be more goods focused. Let's see, agriculture, we actually are a net importer these days of agricultural products, and so the retaliatory nature of these tariffs from things like China, the import tariffs themselves are going to raise the price of food for consumers. The retaliatory tariffs from countries abroad are going to reduce our domestic prices from the perspective of our exports. That's true not only of our outputs, but also it makes us vulnerable on the input side. So fertilizer price is going to go up. Labor shortages, as it becomes harder to migrate to the US, our vulnerabilities with respect to farm workers are intensifying. Currently, constantly kind of increasing our reliance on automation, but that's not happening fast enough to kind of fill these immediate gaps that we're likely to see under the Trump policy. With respect to manufacturing and industry, it's true that some of these plants will benefit if they're currently operational and they are going to be receiving protections from competition abroad, but we also have to think about these things in a system, right? So if I am relying on inputs, just like the agriculture sector, if I'm relying on fertilizers, which are coming in from Canada, those things are experiencing higher tariffs, I'm going to have upward pressure on my cost, right? So this matters. People have highlighted the potential for us to bring manufacturing back to the US, and maybe kind of in a longer run story, that potential exists, but there's not necessarily, it's not necessarily true that will happen in rural places, right? So where, to the extent and the where of that is sort of uncertain. Let's see. In the 2018 trade war, this is our historical farm payments to farmers by government. We had the market facilitation payments, which gave farmers the largest payments they'd ever received in history. We know that the trade war that we've got now is even bigger than that one. To what extent are we going to have to reimburse those injured by the trade war? These things translate into community development impacts. I'm getting chat messages here that say, hey, time's up. So I will, for the sake of following the time, skip these, but we can come back to them if we need to. Let's see. So final reflections. Yeah, rural America in a real sense is where is the location that delivered Trump's win. But it also represents kind of the front line in terms of the impacts of these trade policies and these immigration policies. But the extent to which these things translate into net gains, net losses, and the magnitude of those changes depends on sort of the decisions the court makes about some of the legality of these birthright citizen laws, the legality of the use of some of these rules for our tariff policies. It depends on how markets adjust both to this uncertainty, but how resilient they are to some of these policy changes, and how communities adapt to these increased stresses. And so those are sort of the determinants for what will happen to rural America as a result of these changing policies. Thank you very much. That's all I've got. And here are my details if you have other questions or thoughts.
Thank you so much for your time today, Dr. Schaefer, and thank you for that fantastic presentation. And our third panelist of the afternoon is Professor Lauren Velastro.
Thanks again for inviting me here to speak to you all today. I have learned so much from all these panels and am so appreciative of the real wealth of information we've had. I also just want to harken back to the professor who introduced the whole conference in the morning and said there was going to be some spicy panels. You might be the first person in human history to call retirement policy discussions spicy. So thank you for that. I'm really going to try to live up to that. And with that, this is what I want to talk to you all about today. I'd like to set the table and kind of talk about where we are with respect to Americans' retirement outlooks right now. I'll talk a little bit about what I've done to write this paper, and then how I identified some of the key issues that we'll discuss. And then I'll conclude with a few broad takeaways. So I imagine that many of you in this room are probably younger, maybe 20s, maybe early 30s, and maybe you're not thinking a lot about retirement. But you should be, because if we keep going down the road that we're going down right now, there won't be any Social Security for you or for me. Right now, we are at the verge of a humanitarian and political, and I will add, an economic crisis too, because Social Security is going to fail. It's going to become insolvent by the year 2034. Now, right now, today, it's not insolvent. And even with Social Security, most Americans need a lot more money than they have in order to live above the poverty line in retirement. A lot more money. What might be a little surprising to you all is that most middle-class Americans, folks who've worked their whole lives, who've saved, who've done all those things that we know we're supposed to do, when they enter into the retirement era of their lives and as they become more elderly, they actually face a real steep downward trajectory into poverty. And that's with Social Security right now. And let me tell you about the effects of Social Security. For about half of Americans, Social Security provides almost half of their retirement income, or actually more than half of their retirement income. And for the other third, it provides, or for the other 60%, it provides about a third of their retirement income. So it's very imperative that we figure out what to do with Social Security, because if we don't, we're going to have millions of elderly Americans who've worked their whole lives who are living in poverty. Now, again, Social Security is going to be insolvent by the year 2034. Unless some of the policies we talk about today get enacted. Some of President Trump's policies are actually projected to hasten the insolvency of Social Security by several years, making it move up to just 6 years from now. Now, since we're in an academic conference, I will just kind of throw at you one of the frameworks a lot of retirement scholars use to think about what does our retirement savings look like? What is it comprised of? It's comprised of three pillars, or a three-legged stool, some people say, and that's Social Security, individual savings, so that's what I have in my bank account, whatever cash I have in my bank account, and then my employer-sponsored savings plan, maybe my 401k or a defined benefit pension plan. And I have that asterisk because a lot of Americans don't have access to employer-sponsored savings plans, which is a real problem. And so what that means is that they have a two-pillared retirement structure. So already they have a lot more to deal with. And here we've been told that one of those two pillars is about to crumble. And I think what you'll see in my conversation with you is that really some of the policies that the president plans to enact or is in the act of enacting actually really cut across and erode all three of these pillars, which is normatively pretty concerning. So what I've done to prepare for this conversation with you and to write my paper is I've taken a look at the present economic and political landscape. You heard from really fantastic scholars on that already, so I won't belabor that. I also took a look at what President Trump did in his first administration with respect to retirement policy. Then I took a look at his campaign platform, that of the Republican Party, as well as the policy reform proposals in Project 2025, which is a policy manifesto that, as President Trump has recently been inaugurated, as soon as he got inaugurated, he has been running quickly and enacting a lot of these policies. So I think we can assume that it's likely he may continue to do so. Finally, I took a look at not only some of President Trump's current business ventures, and as Dr. Conklin, my friend Michael said, President Trump has some real interest financially with respect to cryptocurrencies, and that's something we'll talk about. And then I also looked at what he did in his past business ventures with respect to workers' retirement security plans, and like the 401k plans that he provided his employees. And on balance, they were very, very subpar, very below the industry average, and his workers end up retiring with far less than most people in similar jobs employed by others. Lastly, I looked at the appointments and the statements made by the political appointees that President Trump has recently nominated and or has recently confirmed, and what they've been up to in this few early weeks of the administration. So with that, these are the issues that I think are most important to talk to you about. I started out with Social Security. So you might be wondering, well, what is the president going to do about that? Actually, nothing. There is no policy proposal at all right now to address this absolute humanitarian, economic, and political crisis that is occurring in only a few years from now. So that's, I think, a real opportunity for the presidential administration to come in and do something. And so far, we haven't seen any indication that is going to happen, but we can hope that it will. Now, President Trump does have two policy proposals for Social Security and the Social Security system. One is pushing back the age of eligibility for Social Security distributions. On balance, what that's going to do is it's going to reduce most people's benefits by about 13%, because everybody's got a finite lifespan. And if you push back how long you're going to receive Social Security, you're just going to get less. So in this instance, it's kind of a less is less situation. Now, another thing that the president has very, very vigorously campaigned on is abolishing taxes on Social Security distributions. And I think a lot of folks initially might say, oh, that sounds really great. You know, that's going to give people more to live on in retirement. And that might be true if not for that first bullet point up there, which is that we have a looming Social Security insolvency. Now, if things were done to address that, the third policy proposal might be helpful to many Americans, but as it stands now, what it will do is it will actually move up that insolvency by several years. Next, a few more things that I think are worth talking about when we're thinking about what the president's going to do with respect to retirement plan, or retirement policy rather, is take a look quickly at the fiduciary rule. I'm sure you all have heard of fiduciary obligations, and I'll give you a little history on what this rule in particular stands for. In 2016, the Department of Labor rolled out a fiduciary rule that said that if I have non-employer sponsored savings, like just my savings in my bank account, I want to go and I want to invest it, that my financial advisors should put my financial interest ahead of their own pecuniary gain and their own interest. The Department of Labor rolled out this rule after a 6-year comprehensive study finding that many Americans were actually getting the wrong advice from their financial advisors. Their advisors were pushing them into these investments that had really high fees and less returns than were optimal, whereas they could have got low fee and higher return investments, but they may not have made as much money for the advisors. So of course the DOL implemented this rule that said, hey, no, you've got to put your clients first, just like we as lawyers have to do. Well, President Trump did away with that rule in his first term. President Biden brought it back, and now we know President Trump is planning on eliminating the rule again. The problem with that is that back in the first term, we economists were able to figure out that this was going to cost Americans about $20 billion a year in their retirement savings. And so I think we can project that it's going to be that much or more. And just to put a finer point on this, I have a paper coming out in a few weeks with the George Mason Law Review, where I show that just like a 1 or 2% fee, like a very small fee when you think about it, over the course of our working history or our working span and our investment history, that fee can erode up to half of our savings. So a small fee that's going into the pocket of my investment advisor instead of helping my nest egg grow can be very, very substantial and very harmful. Last two issues that I want to raise for you, and it was great to have Dr. Conklin talk about cryptocurrency. I'm going to approach it a little bit different way because I think a lot of the things that Dr. Conklin said were totally right. And despite some of the real serious concerns that there may be with respect to investing in cryptocurrencies, the bottom line is people are doing it. And what we know is that many people are now actually investing their employer-sponsored retirement funds, so money like in their 401ks, into cryptocurrencies. They're doing that in two ways. One way they're doing it is through what's called their plan menu, and they're able to choose investments, and that's a okay kind of thing to do because we know at least that there is a very defined legal and regulatory regime. If something bad happens, we know where liability is going to lay. We know who's going to be responsible, how people can recover their money if appropriate. And now the other way they can do it, and the way that most people currently invest in cryptocurrencies through their retirement plans, is actually through what's called a brokerage window. These are mechanisms that let you go and basically invest in anything in the stock market, and there are not a lot of safeguards. Really, there are no safeguards there. And the problem with that is that their brokerage windows exist in a complete legal and regulatory vacuum. Nobody knows how people could be protected, if people could be protected, who might be responsible if people lose their money through these investments. But we do know that they are happening, and they're going to probably increase with a presidential administration who said that he plans to be a crypto president and a crypto-friendly administration. So this is a real opportunity, I think, for the Trump administration to come in and put in parameters that can help protect Americans' retirement funds. Whether that will happen, it remains to be seen. I haven't seen any suggestion that there will be, but I'm working on a project where I hope to propose some parameters and see if there can be any traction there. Now, the last issue that I want to raise with you is something that I'm sure you've all heard of. It's environmental, social, governance-oriented investments. The president has made it extremely clear that he is hostile toward these types of investments. And that's a little bit, I think, ironic because that stands at one end of the spectrum. And on a completely other end of the spectrum, the president has also embraced a real willingness to intervene and to promote investment of retirement funds in more nationalistic type of investments, and to really kind of scare fiduciaries away from trying to invest in some foreign-oriented funds, and actually threatening to go after people who administer retirement plans if they were to invest in funds that might have ESG-affiliated investments or might be associated with Chinese investments, stuff like that. So we have a little bit of a tension with respect to some of these paternalistic interventions and what the government and the presidential administration is saying we can do with our own money and the money that we earn and save and are saving with for our retirements. So with that kind of leads me to my big takeaways, and I'll just talk about, I think, a little bit of the regime shift with respect to that ESG, and intervention and paternalism. I think in past years, Republicans and conservative politicians have expressed a real commitment not to intervene in what we do with our own money. It was kind of hands off, this is your money, we're not going to mess with it. Now we are seeing this shift into a position where the Republican Party and President Trump in particular is very comfortable going in and saying, if you're doing something, if you're going to invest your money in what might be perceived as a liberal type of investment, we're going to stop you. We're going to penalize folks who enable you from doing that. That's, I think, a very interesting shift away from that freedom of economic choice and individual choice that you might have previously associated with the Republican Party. My final two takeaways are this. When we increase investment in something like cryptocurrency or use these brokerage windows that have no real legal and regulatory regime, what we do is we also increase uncertainty. The same is true just about everything everyone's talked about all day. All of these economic changes and policy changes cause there to be a lot of uncertainty with respect to what investments are prudent, what we should be putting our money in order to try to build up that nest egg for retirement, which becomes all the more important, right, when we know that we don't necessarily have a social security system to fall back on in a few years. And really, when you think about uncertainty in the retirement context, it just hurts everybody. It hurts workers, it hurts the employers who sponsor these plans, and it hurts even the fiduciaries and the industry professionals who are trying to administer these funds. So that's normatively just really undesirable. Now, the last thing and the most important thing is going back to Social Security. Altogether, cumulatively, a lot of these policies are going to hasten the impending economic and humanitarian crisis, the downfall of Social Security, if nothing is done. And what we're going to see is that a lot more Americans are going to be living in poverty. This is a really great opportunity for the president to step in among all political issues in the United States. Fixing Social Security is one of the only ones that gets almost complete support from every end of the political spectrum and everywhere in between. So hopefully the president will do something. But right now, when we have an action on Social Security coupled with tax reductions, coupled with increased uncertainty and eroding our private savings and investments, what we see on balance is just a real diminished retirement outlook for American workers. And I hope very much that the president will intervene and revise some of these policies in order to protect the people who have put him in office. So with that, thank you so much for your attention. I really appreciate having the opportunity to speak to you.
Thank you, Professor Valastro, for your time today and for your very thought-provoking presentation. We will open up the Q&A for all of our panelists now, if we have any questions.
And I have questions for each of the panelists. So if that's all right, I shall begin. And I have a couple of questions for Professor Olteanu. And the first question I have is the question of the representative states of Eastern Europe, Poland, Hungary, and Romania. But there's a great deal of complication to Western Europe. Western Europe is a very, very complicated place, or Eastern Europe rather, very, very complicated place. And you could also just as easily select Estonia, Latvia, and Lithuania as Eastern European states. They have very different standing and status, or you could, for that matter, select Russia, Belarus, and Ukraine as Eastern European states. So the choice of Poland, Hungary, and Romania, are they truly representative? And I think that's my first question. But I also have a second question. Toward the close of your paper, you point out three scenarios that we could, each of which we could foresee. Reinforced bilateral developments that weaken NATO, greater strategic autonomy gains, traction within the EU, and we see digital decoupling of the EU and the United States. And I don't see these as mutually exclusive. I see them, in fact, as potentially mutually reinforcing. Each of them could reinforce the other into a spiraling decoupling of the United States and NATO. So those are my two questions to Professor Olteanu. I have a question for Professor Schaefer, and that question for Professor Schaefer is this. What happens in the rural economy does not stay in the rural economy. And I see, coming out of your presentation, two sources of disruption that have the potential to cause significant inflationary pain for all Americans. And that is first, the exposure to international trade in rural America. Tariffs, as you point out, are disruptive, increase costs, and these increased costs get passed on. Then we have already a problem with a shrinking workforce in rural America. And as farm workers and potential farm workers face the issue of deportation, will this not also put upward pressure on prices for all Americans? That's my question to Professor Schaefer. And Professor Velastro, a question for you. The insolvency problem with Social Security, I've always seen as a kind of artificial problem. It's a self-made problem. It could easily be fixed. There are easy fixes. If we simply, for example, with the Social Security payroll tax, simply cease to cap the Social Security payroll tax. Or if we take capital gains taxes, which are used as a primary form of compensation in many industries, and simply impose Social Security taxes on capital gains taxes, particularly where they're used as a primary form of compensation. Would that not help solve the so-called insolvency crisis facing Social Security? So I'll be, Professor Olteanu, I guess we'll begin with you. Would you be so kind?
Yes, sure. So for the first question, yes, it's interesting, and I thought I should give more attention to Baltic states, and to Belarus and Ukraine. In Belarus, the situation is almost the same for 30 years or something. So they have almost the same policy as Russia have in terms of foreign policy. Why did I choose Hungary, Poland, and Romania to be more explicit? Poland exemplifies alignment with the US defense agenda, have a consistently exceeding NATO spending targets and advocating for an increasing US military presence. Hungary under Viktor Orban illustrates a turn toward strategic autonomy and a raise of nationalism. It cooperates both with US and Russia and has frequently clashed with the EU on rule of law issues. Hungary offers insight into how smaller powers navigate great power on competition. And Romania provides a case of balancing between EU strategic interest, as I said, on defense and energy and tech partnership, and Romania had also a firm commitment to EU legal standards and anti-corruption norms. So a diplomatic response will be that Romanian position makes an example of diplomatic agility. And to explain more the three scenario, the first regarding the reinforced bilateral deals that weaken NATO occupation. This scenario suggests that Trump knows for favoring direct country-to-country agreements over multilateral institutions could prioritize individual security deals with certain European countries. The impact will be that This approach could sideline NATO, which is based on collective defense, Article 5, leading to less unity and cooperation among member states. What is the most important thing if countries really rely more on US bilateral protection than NATO, the alliance could lose relevance and internal trust could be eroded, weakening transatlantic security. Regarding the strategic autonomy, strategic autonomy refers to the EU ambition to reduce dependency on the US. But now, because when we are talking on the last administration, in Biden administration, I could remember a speech from President Emmanuel Macron, which he said that we need more autonomy from the US, but none could see that he had a vision regarding what will happen on this matter. So if Trump reduces US engagement in Europe or questions US commitment to NATO, EU countries may feel they need to boost their own defense and geopolitical influence, and the result will be that you might invest more in its own military capabilities, foreign policy tools, as we see right now, to have a more industrial self-sufficiency, moving toward a more independent global role. So in this occasion, European Union as thinking as a bloc, as 27 states, maybe this could be the second power of the world, or maybe the third. So we see right now US and China, who are China is maybe an emerging, which is also a great power. But I think that in this case, EU will think more on becoming self-own great power. And regarding the digital decoupling between US and EU, I'm referring to growing divergence between US and EU in tech regulation and digital policy. We see a lot of acts. AI Act is most recent one, and I see this one is to regulate some of the companies from the US. An example, differing stance on the privacy, GDPR in the EU versus more lenient use rules, as I think. And I saw in some speeches, also in J.D. Vance's speech, that EU regulate more, and which is true. And also Mario Draghi, in his report, said that EU should relax his regulation to let companies become more competitive with the US companies, so to prevent this type of questioning. But yes, this will be interesting to see in the future. With Trump, if his administration takes a nationalist or degradation-heavy approach into tech, it may be a gap with the EU, which typically favors stronger consumer protection and tech oversight. The outcome, I don't know. Maybe less alignment in digital trade and tech cooperation, potential barriers for cross-Atlantic tech companies and the innovation sector. I think this will be in the third case. Yeah, I hope I answered to.
You did. Thank you.
Thank you,
Professor Schaefer.
Yes, let me briefly remind people of what your question was. So you were arguing, I really liked your sentence. You said, what happens in rural America doesn't stay in rural America. And the fact that these price pressures that I was discussing, putting pressure on kind of the rural economy, if we're experiencing prices for our increased prices for our food, agriculture, that's going to translate down the supply chain to consumers, not only in those rural areas, but also in urban markets as well. I think, is that a fair representation of?
That is, yes.
Great, yeah. So I agree almost with you on both of those points. So I agree with you that what happens in rural America does not stay in rural America. I want to make clear that we're talking about tariffs from two dimensions here, right? We're talking about import tariffs. Those are what Trump is imposing. And absolutely, if we are importing a product from abroad, so those things that we're reliant on other markets to access, an import tariff is going to increase the price of those things. In addition to that, we're also concerned about the retaliatory tariffs that other countries are imposing on us. If we are exporting a product and another country hits us with a retaliatory tariff, that's going to drive down our prices. We know that every single person in the US economy is actually two different people. One, they are a supply side operator, so they operate in sort of the production space, whether they're making goods or performing services. In addition, they're a consumer who's demanding food, right? And so we're impacted by these things in both of those dimensions. My point, I think, was that the rural economy is uniquely exposed in both of those dimensions. Because the rural economy tends to be much less diversified and much more goods-oriented than urban economies, we are uniquely reliant on or exposed to trade policy changes relative to urban areas. From the consumer side, we're also more exposed to changes in our grocery bill because rural economies, people in rural places tend to be poorer on average than people in urban places, right? So food represents a bigger share of our disposable income. With respect to your last point, doesn't this, and then I'll stop talking, I promise, but your last point here is, don't these prices, these price pressures just get passed down the food supply chain such that consumers are ultimately the ones bearing the brunt of that? And the answer is maybe. In perfectly competitive markets, absolutely, that is how that works. The problem is that the US food industry is not an example of a perfectly competitive market, right? We've got these big middlemen, processors, wholesalers, retailers that have quite a bit of market power, both upstream and downstream. And when we have this kind of middleman market power, those price increases may not ultimately get passed through to the consumer. So farmers may have to take the hit, take the brunt of those price changes. On the other hand, maybe that retailer is able to absorb some of those price increases in a way that doesn't affect the farmer as much or the consumer as much. So it's super nuanced and specific to each individual commodity there, I think, is my final answer to that part of the question.
Well, thank you.
Yeah, thanks.
And Professor Velastro.
Yeah, so you asked whether we could easily fix Social Security insolvency by maybe removing caps on payroll taxes or imposing them on capital gains. And the answer to that is a very lawyerly answer of yes, but, and the but pretty much swallows the yes. The problem is not that there aren't any fixes. There are a lot of scholars and economists who have proposed plans that could be implemented that could save Social Security. But the but is that so far, no one's been willing to muster the political willpower to implement these. We have what I think is fair to characterize as a rather unpredictable president who some would certainly suggest is implementing policies that are maybe more friendly to the wealthy than to the average worker, and therefore may be disinclined to embrace something like removing payroll tax gains and imposing capital gains taxes that would go back to Social Security. So that strikes me as somewhat unlikely. And then we also know that in the past, President Trump has really fluctuated with respect to his perspective on Social Security. At one point suggesting that maybe we shouldn't have Social Security at all, saying it was a Ponzi scheme. at another point suggesting that it should be privatized, and then at another point suggesting that the retirement age should be pushed all the way back to 70. So his position seems to be very dynamic and maybe not as fixed as we might want there. But yes, I think there are solutions. Someone just has to muster the political willpower to implement them.
Tax the rich. I mean, we hear that as a slogan, and that it may also be a solution.
I totally agree with you. I will wait with bated breath to see if anyone is actually going to go there.
All right, I want to thank our last panel for their very insightful comments on this very important topic. And I just want to say a thank you to all of our speakers today who have joined us, and for all of the Symposium Committee and all the speakers for being here. And I'm going to pass it off to Professor Reed for final closing remarks.
And I just want to say, reiterate, yes, thank you to all of the participants. It's been I think we've had here today, I hope we've had an important symposium, important in the sense that we can perhaps foresee, perhaps even influence the future path of public policy in what I think is a highly unpredictable time. But with our best efforts and best lights, perhaps we are able to have some influence on all of this. And so I want to thank everybody for stepping forward for presenting very good, very lucid, very important papers. And I just want to say, in addition to that, have a wonderful weekend. We look forward to your final papers. What's the deadline in the final papers?
I believe it's July. I'd have to double check on the specific date.
We look forward to the final version of your paper sometime around Independence Day. Thank you.
Thank you, and one more round of applause.